glasses first. Good evening and welcome to the monthly meeting of the Arlington Board of Zoning Appeals, which is also known as the BZA. I am Terry Russell, Chairman of the Board. The board is made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Charles Smith, Inta Malice, Judy Freshman, and Paul Melnick. Also present is the professional staff, including Deputy Zoning Administrator Andrew Noxon, who serves as Secretary to the Board of Zoning Appeals, Deputy Zoning Administrator Essie Corbin, Clifton Hogan, Assistant to the Zoning Administrator, and Cheryl Williams, Zoning Technician. We thank you for being here and extend a warm welcome. To avoid disruptions, we ask that you please turn your cell phones or pagers off or put them in a silent mode. On the front table, you will find copies of the staff report for each case before us this evening. I recommend that if you have not yet seen that report for your case, that you get a copy and review it before your case is called. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county zoning ordinance adopted by the county board. The BZA does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the county board. This board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow such modifications. We can grant variances from the specific requirements of the zoning ordinance, and we can decide appeals of decisions of the zoning administrator. This evening, cases will be called and a brief staff report and recommendation will be given. Following that, board members will ask any questions of the staff they may have. Next, applicants or their representative will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so their comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker's slip, which is available on the table in the front of the room. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit and will not condone any cross-examination or direct questioning by others. After the board has gathered all the information they need and discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the Circuit Court in accordance with state law. After your case of interest is heard, you are welcome to stay for the balance of the session or leave at your convenience. Thank you for being here this evening. Please call the first case.
Thank you very much. Our first case tonight is V-11052-15-UP-2. This is a use permit request by Kyle and Alexis Conley to permit a setback of 5.4 feet to the eave and 6.5 feet to the wall from the right side property line instead of 16 feet as required, and also an aggregate side yard of 13.5 feet instead of 24 feet as required. It's for the construction of a new 2-story right side addition. It's in the R10 zoning district on the premises known as 2713 North Pollard Street.
Staff is recommending denial of the use permit, but has provided us with an alternative resolution in case the board wishes to approve the use permit as requested or in a different form. Do we have any questions of the staff? If not, I'll go ahead and call the speakers. Give me just a second. I will call the applicants together. They filled out speaker slips. Alexis and Kyle Conley, would you come forward and speak about your case to us?
Hi, how are you?
Hi, good evening.
Kyle, this is Alexis, I think.
Welcome.
You want to kick it off?
Sure. We bought our house in 1999, so we've lived there almost 16 years. We love our neighborhood tremendously. We don't want to move anywhere else because we have 3 children who are entrenched in our neighborhood activities, as well as our schools, our neighborhood pool. They're 15, 13, and 9. And Kyle and I volunteer a lot. Kyle is the coordinator for the local soccer league, the ACES, which is part of Arlington Soccer. And I volunteer a lot at our pool, so the space we want to be and the place we want to stay. As the kids have gotten older and as Kyle's been given the opportunity to telecommute more from home, we looked around and realized we need a little more space to help everybody achieve their goals. And we decided to make an addition to our house. Let's see, what else I want to say? Basically, we decided to stay within the actual footprint of our home. And it's a tricky house with split level. Someone else might speak a little bit more about that, but we decided to stay in the actual footprint, and to make what we wanted to work, we decided a 2-story addition in the current porch of the picture you see there would be give us the space we needed and be most useful to us.
Sure, let me
Yeah.
give you an idea of the size of the home, and our architect, Frank Durkin, will come up and speak after us. But we have about 1,624 finished square feet. So we'd like to add about 1,000. So it's still, it's still under, 3,000 finished square feet. And just to go back, not to get too much into the details of the reasons why we'd like additional space, as Alexa said, I'm currently now allowed to work at home. It's not something I was able to do before, so hoping to get an office space. Additionally, I help run the Arlington Soccer Association Recreational Soccer League, so I have probably 1,000 cubic feet or a few thousand cubic feet worth of balls and equipment and stuff that I store at the house, and so one of the things that we're adding on is additional storage space. I think the other, Frank will speak to this, but the other thing that's sort of I would think is kind of a mitigating factor for this particular project is that while the front of the house is 28 feet from the street, it's really the addition, the addition onto the porch is about 50 feet from the street, and you can't, if you guys have the pictures, but you can't see it from the street. I think the other important point here is that we spoke to all of our neighbors. All of them are in support of are doing this and improving the property in this way, including the neighbors on the right side, who you can see that in that picture that's up on the screen right now. The Davies live on the right side. They're actually here to speak if necessary in support of the project. If there's any questions of us?
Well, let's see. Do any board members have questions of the applicants before we move on?
Very quickly,
Mr. Smith.
Mr. Chairman, I don't have a topographic. Thank you. I don't have a topographic map, so I don't know what the change in elevation is. It appears, though, that your property slopes from front to rear.
So it
Front, rear to
yeah,
front.
so it slopes up pretty quickly from the street, and then in the back, like in the backyard, it's a gradual slope to the rear of the property.
Okay.
And then, I think the other important point is that, we're not expanding, the footprint's the exact same for these plans. So we're adding that, we're adding a level to the main part of the house, and then would like to go over the porch, because it is, while it's adding a level, it's really, because it's a split level, it's really only adding a half level to the house, because it's the one side, so.
So I see the staff in their report and requesting denial of this. They're saying that in the area there's 1-story additions, this close but not 2-story. And did you all consult with the staff to see if there was any middle ground, and was there none? Just to try to get the staff to approve to come into some sort of, more, just get more approval from the county. Did you all make efforts on that behalf?
We weren't able to do that. We didn't see the decision online until recently, until a couple days ago. Okay. So, we did talk with our architect since we saw that. And I know he'd like to speak about sort of the aesthetics and the options. We did. That is one of the things that we considered. Is one of the things in the decision. And the decision said, they have space in the back of the house. Why don't they go out the back of the house? And that is something we considered initially when we spoke with our architect. And he just felt, and we felt, just aesthetically looking at the plans that the proposed plans for going out the back, that it more expensive, and B, it didn't work with the space. And C, the other thing that's important, I think, to me with the kids, and also knowing about the general space crunch in Arlington, is that eating into my backyard, even though it would only be a couple of 250 square feet, makes it a different play space for the kids, and it's taken away that green space that we currently have. So,
Okay, thanks.
decision making.
Ms. Freshman? Oh, okay. Okay, well, should we hear from your architect or you?
That'd be great. Thank
Frank
you very
Durkin,
much.
please.
Good evening.
Good evening.
I'd like to first just pick up with what Kyle was saying, Mr. Conley was saying, about the difficulty of, well, from a zoning standpoint, it might be the easy solution to go out back. It's actually, architecturally, it would be very difficult and expensive, change the drainage of the land. And this is a rectangular house. It doesn't want to be an L-shaped house. It would just really kind of a non-starter of a solution. That picture that's on the screen right now, I think, is the key picture. That is what you see. I went out to the site to survey it many months ago, the first time, and I was trying to take pictures of that porch, and this is as best that I could get. Because of the curve of the street and because of the change in the slope going towards the back of the property, and because of the density of the foliage, you cannot see this parcel of this portion of the parcel at all. We have spoken with the general contractor and an arborist, and they feel that we can actually maintain the magnolia, which is the primary consideration here. It's about a 40-foot tree. The roots are about 12 feet from the addition, and they think that we can save this if the Conleys are willing to add the expense of taking the long way around the house with the equipment. So if we do that, I feel confident that you're not going to see the second-story addition. And I'd also like to reemphasize that when this house was built prior to zoning considerations, the porch that was on the side was considered a reasonable distance from the neighbor. And we have the neighbor here who agrees and has seen the design and is not discomfited by the addition of a second story to that same footprint. We're not asking for any additional footage to that side. We want to respect what's there. Unfortunately, it's on a crawl space that's crumbling right now, so we can't just fix it. And in going through to excavate a new basement, we would like to capture the second floor because the split level of the house really does not provide enough room over the existing garage to give a comfortable master suite and office for Mr. Conley, which is why we're looking at the porch at all. As the staff has indicated, we are not trying to change the landforms at all or anything historical. It's really about the foliage, and we are willing to proffer a statement that we will make our best effort to maintain the existing trees that are there, and if construction is construction, if something were to be damaged, that we would replace with obviously a less mature tree, but still not a sapling, in order to maintain the character that's there now.
Thank you. Why don't we go ahead and, does anybody have any questions for the architect? We hear from the speaker, and then I have a question or two, and I'm sure others will. Bankhead Davies, please.
I felt that my responsibility to come and at least echo what the Conleys have indicated. I will say that my favorite room in our house is the one that's adjacent to their house. I enjoy going out there, and I do not feel at all that what they're going to do is going to impact on us. And I always look at improvements to the neighborhood, something that's a positive thing. And I think I've looked at their drawings. I think that it looks like a wonderful plan, and I hope you all will consider that. In any event, I don't know there's much more that I can say than that, but it's not, this addition isn't anything that concerns my wife or myself. I don't think it's going to impact on us. We are the only house that I think that might impact, but again, it doesn't really concern us at all. So hopefully you all will see to give them a variance on this.
Okay,
That's it.
thank you very much.
Thank you very much.
Thank you. I have a question for the staff, just to clarify for the record. Their proposal is to take the existing footprint and go straight up, correct?
Well, they would have to reconstruct the first floor as well.
Yes, but they're encroaching now as much as they would encroach afterwards, except
That's
for the
correct.
second story. So this is an R10 lot, which has wider requirements for aggregate side yards, but does allow you to have either an 8 or a 10. And so when you read some of these numbers, like 6.5 instead of 16 feet, that's in a conforming lot, that actually could be 8 if the other side was.
Well, the other side would have to be 16 if you have an 8, yeah, as opposed to a 10 where you have the R5 and R6.
It just gets confusing. The numbers look larger than sort of they really are. But so this existing porch on the right side would be taken down, and back in place of the porch, sort of in its exact dimensions, house would be constructed, but that would go up for 2 stories.
Right.
Other than that, they can do what they're doing as a matter of right?
All the other construction, exactly.
Center part.
Now, the fact that this is a porch now would preclude them from building up by right now.
Right. Right. Okay, thank you. Any, Ms. Malice?
Question for staff. The applicant, or as the architect, made the argument that the addition would not be visible from the street. From strictly a zoning point of view, is that material in terms of determining whether something is appropriate?
I don't think we would really take that into account when we're talking about a side yard setback. Now, if it was from a front yard standpoint, maybe we'd look at it differently. And there is a case tonight, 4007 20th Road North, where you'll see that similar situation.
The applicant has also, or at least this architect, has offered some, has proffered the idea of keeping the foliage that in fact does sort of obscure the addition. I think we've added conditions like that before.
Correct.
I'm a little hampered by the fact that we don't have a landscape plan that actually shows what trees are involved. Do you have anything more than this that might, if we were to go in that direction?
I would think, if anything, you could ask them to submit a landscape plan with the building permit, if it comes down to that, for staff to review, and you could say maybe do a 1-to-1. If you remove one tree, you have to add one in its place.
Okay, and because they mentioned a significant magnolia that is providing a lot of coverage right now, and the root area would require protection. Normally, that's what we would do, is have some kind of protection of the root area. So that could also be a condition that those protections
Correct.
be included. And I think the third thing they mentioned was actually having all their excavation equipment go in through the other side of the lot. And again, is that a reasonable condition, or is that an appropriate condition?
Yes, I would think so.
Okay, thank you.
Any other board comments? Motion?
I move that the Board of Zoning Appeals adopt the, oh, is there an alternative motion?
There you go. There you go. See it on page 5.
I'm looking for the language, the motion language. Okay, so I move that the Board of Zoning Appeals adopt the alternative resolution, which would approve the use permit V-11052-15-UP-2 with additional conditions. One, that construction equipment enter the site from left-facing side of the house, that a root protection zone be created around the existing magnolia, and 3, any damage or non-surviving plantings be replaced on a one-to-one basis.
Second.
The motion has been made and seconded. Any comments? All those in favor say aye.
Aye.
Aye. Opposed? Motion carries 5-0.
All right, next case tonight is an appeal. I'm going to go ahead and call out the case, and then we're going to have a staff presentation from our Assistant County Attorney, Min Chao Kaur. It says case number V-11026-15-APP-1. This is an appeal by Glebe Road LLC and the Majestic Oaks Homeowners Association, Incorporated, to a notice of violation regarding condition number 46 of Site Plan 373. It's in the R15-30T zoning district on a premises known as 1305 South Monroe Street.
Good morning, members of the board. Sorry. Good evening, members of the board. My name is Min Chao Kaur. I'm an assistant county attorney, and I'm here to represent the zoning administrator in this appeal. The reason I'm here is because we have a unique situation with this case in that what is before you is a pure legal question, and that question is whether the deed that was actually granted to the county by the appellants satisfies the condition of an existing site plan that was approved by the county board. And the reason I say this is a pure legal question is because, as you know, a site plan that is adopted and approved by the county board is an ordinance. It's an uncodified ordinance, but it is an ordinance, and as such, it operates with full force of law, and the only entity with the ability to alter or amend that site plan in any way is the county board. Therefore, the only question before the Board of Zoning Appeals is whether the zoning administrator was correct in determining that the applicants, the appellants here, violated that site plan condition. And it is, I think, quite clear that they are in violation if you simply compare the language of the actual deed with what was required by the site plan. I will refer you to first the site plan conditions, which unfortunately pages are not numbered here, but they start on what is labeled as Exhibit B to the Declaration of Covenants, Conditions, and Restrictions, which is about 2/3 of the way through the packet. And I'll refer you to condition number 46, which is the condition that was cited by the zoning administrator. And it says, the developer agrees to grant a permanent public easement to the County Board of Arlington County, providing for public ingress and egress, access and use by the public at large, and by county emergency fire and police vehicles over the private internal streets and sidewalks. Now I'll refer you to the easement that was actually granted to the county. Which is about 1/3 of the way through the packet. It's on page 9. On a page that's labeled page 9, I should say. And the heading there says easement for ingress, egress, public utility, emergency access, storm drainage, and parking. And if you look at that language there, it says, further witnesseth that for good and valuable consideration, the receipt and sufficiency of which are hereby acknowledged, the owner, with the consent and approval of the trustee and note holder, do hereby create, grant, and convey unto the county its successors and assigns an easement for ingress, egress, public utilities, emergency access, storm drainage, and parking over, under, and across and through the property in the locations and dimensions shown on the plat for the purposes of construction and or maintenance of public utilities, and for the purpose of ingress and egress by county police, emergency and maintenance vehicles and personnel, subject to the following condition. So as you can see there, that easement that was actually granted is limited in its scope to only emergency access and county access. Nowhere in that easement that was actually granted is there an easement for access by the public at large, which is what the county board required in condition number 46, which is why the zoning administrator cited the declarant and the homeowners association for failure to comply with the site plan. Also attached to our packet is the plat itself, which was recorded along with that deed of easement and re-subdivision. And if you turn to the second page of that plat, the easement in question starts from between, it's basically the right-of-way between lots 23 and 24, and should run all the way down to in the middle of lot 21, basically. And you'll see that it's called out. It says easement for ingress, egress, public utilities, and emergency access hereby granted. That's the summary is marked on the plat, and that's how you know that's the easement that corresponds with the text in the actual deed that was granted. So as you can see, the text of what was actually granted to the county does not match what was required to be granted to the county. It is, in fact, more limited in scope than what was approved by the county board. And at this point, although you will hear evidence, and we have tried to work with the applicant to resolve this matter, and you'll hear compelling arguments, perhaps, as to why the street should remain the way it is. There's just the zoning administrator and the Board of Zoning Appeals just does not have the authority to give the applicant what they want. The zoning administrator does not have the authority to amend a site plan, nor does this board. The corrective action that was required and the remedies that are available to the applicant is to either bring the property into compliance by conveying a proper easement to the county board, or alternatively, to go to the county board and seek a site plan amendment. And that's the proper venue for, bringing up arguments about whether it's appropriate for the street to be a street open to public access. But the question before this board is limited in scope to whether the deed that was actually granted is in compliance with what was actually required by the site plan. And if you have any other questions, or if you have any questions, I'd be happy to answer them.
The board members have a question of the Assistant County Attorney.
Mr. Chairman?
Ms. Malice?
So the county's, your position is that the site plan was not properly implemented.
That's correct.
Mr. Smith?
Isn't the question before us whether or not the zoning administrator was right in saying that the easement wasn't granted?
That's correct.
Okay.
Could you clarify that?
Well,
Whether the zoning administrator who made a determination that the easement wasn't granted in compliance with the condition was her determination correct? And then she issued a violation as a result of that. And so was she right, is the question before us.
right. The notice of violation cited them for violating the site plan conditions.
A yes or no?
Mr. Melnick?
Hi. Could you elaborate on, in condition 46, let's see, I believe it's the second to last sentence. The easement shall be granted by deed in form and substance acceptable to the county manager and shall be recorded among the land records of the clerk of the circuit court of Arlington County, where they say what it's supposed to, the site plan says what it's supposed to say, but then it says it shall be by deed in form and substance acceptable to the county manager. Could you elaborate on your position concerning that? I saw the cases, but if you'd like to address that, what significance them saying form and substance acceptable to the county manager?
Right.
I suppose there could be instances where the form of the language would be slightly different, but so verbatim it might not say exactly what is said in the site plan condition, but I don't think the managers would have the authority to do what is less than what the board requires, because it is a legislative act.
Okay, thank you.
Do we have any further questions of the staff? Not, I'll move to the appellant. Go ahead, call Andrew Bircher, please.
Good evening. My name is Andrew Bircher. I represent the two appellants, or three appellants really, Majestic Oaks Homeowners Association, Inc., Glebe Road LC, the developer, as well as the Lot 24 owner. I have my handouts in
You said the third thing was the homeowners association?
there's the homeowners association, there is the developer, and then there's Lot 24, who's also been cited for this violation. Hand up? Please.
Carol, that's enough.
Turn to the next slide. The first thing what I'd like to do is I'd like to give an overview of what this subdivision is and where it's located so that the board has a good feel for it. But before I do that, I want to jump into what the legal issue and the issue is before the board is whether or not the developer complied with the site plan conditions. And the county is narrowly focused on condition 46 and focuses on the language street, that public ingress egress is over streets. I'd like the board to focus on condition 15, which talks about the area in which they are actually complaining about. And condition 15 talks about, in condition 15A, it says to construct a driveway entrance to the site's 12-foot wide private driveway between units 23 and 24 at South Monroe Street. It's our contention that the plat, as well as the easement that was granted, was appropriately limited because this area is not a street. This area that they would like us to grant a public egress easement on is really a private driveway, as contemplated by Section 15A of the site plan conditions. So with that premise, I'd like to jump into and walk you all through some pictures. And the reason that I'm presenting these pictures is to give you an idea that this is not a street. And there is no way that this should have public ingress egress easement over it. And as a result, that the developer or the HOA or Lot 24 is in violation of the site plan conditions is categorically wrong. So this picture that I've got up now is an overview of the site.
to your right or to my right, the larger road is Glebe Road. To the left is Monroe Street, and the area that's circled is the area in which they contend an easement should be, a public ingress-egress easement is. Turn to the next page. All right, this is looking at the site as you go from Glebe Road up until the area in which they would like the public ingress-egress. You'll note that on the next page that the county or someone has already put up a sign that is a no outlet sign. That was recently placed up there. So the idea that they contend that this should be public ingress and egress is already dispelled by the fact that they put up that sign. So we believe that this is the area, the red line that I have here, as we move closer to the alley, is the area in which they want public ingress-egress. Next slide. As you can see, it starts to narrow and starts to look more and more like a driveway. If you turn to the next slide. This is even closer. Look at the width here. This is not a public street. This is not a street in which you would want to have public ingress-egress, two-way traffic in any way, shape, or form. And you can start to see the two lines that are there going up to Monroe Street. That is the area. Lot 24 is the one that is on the left side of the picture, and Lot 23 is the one that is on the right side of the picture. And again, I refer you to Site Plan Condition 15A, in which that area is considered a driveway between lots 23 and lot 24. So, let's go to the next slide. This is looking in the reverse direction, and you can see how narrow that is. The idea that you'd want to have that as a public street belays reason. Moving to the next slide, please. Okay, so this is a picture of the area between lots 23 and lot 24. So this is what we contend is the private driveway or an alley. It was originally an alley, and there was a lot, as we mentioned in our materials that we submitted, there was a lot of contention over, how to treat this. And you'll notice at the top of the street there, at the top of the driveway here at Monroe Street, there were 3 bollards that were placed there. They've been in existence there for the past 10 years during construction, and they were removed in August by the county as part of this dispute. If you go to the next slide, this shows the view of the driveway area from Monroe Street. If you'll note that this area is not at grade. This is a driveway apron. There are no stop signs. It crosses over a sidewalk. There's only room for a car in one direction. There's limited visibility. And this is kind of offset from 13th Street. And there are no directional signs, no stop signs, none of those sort of things. So all of this was built in accordance with the site plan and those things that were approved by the county staff. And the developer got off bond with those bollards there. In fact, you'll hear a little bit of testimony later on from the developer in that the county actually required us to paint those bollards and change them to the condition that they were there. And my point in bringing all of this up is that this clearly is not a street over which public ingress-egress should be considered appropriate. So, next picture is, if you could, this is looking at it going in the different direction of Monroe Street. And then the last picture, next picture, this is looking at it from basically across the street. So, if you go to the next slide, please. So, interestingly, who are the parties in this case? One of the things that they've said is, we have to either grant an easement to them or, get determined, or a site plan. Well, the developer has been off bond since 2014, owns no property in the subdivision, and it doesn't have the power to grant an easement anymore, does not have the power to file a site plan amendment either. Likewise, the Majestic Oak Homeowners Association, doesn't own this property. These are all the lot owners, the individual lot owners that own these property along this driveway up until the point in which the public street actually starts. And that's that red line that I showed you. All right, so if you could turn to the next slide, please. All right, so I've put up here both condition 15 as well as condition 46. And I've highlighted the language that I think is at issue. Under condition 15, it says that we will construct a driveway entrance to the site's 12-foot wide private driveway between units 23 and 24. There's no indication that that's a street, and that is what is in the site plan conditions. The next, condition 46, which they say the developer and the HOA are in violation of, says that the easement, the public ingress egress will be over private internal streets and sidewalks. This is not a private internal street. This is a driveway, as the language of the site plan indicates. And then it goes on to point out the language that I think, Mr. Melnick, you were mentioning, that in a form and substance accessible to the county manager. This was over 10 years ago, and this was a process in which the developer went through and made sure that the conditions of the site plan were met, and that those conditions were, that the easement that was recorded was in accordance with the site plan. We have no idea why, nearly 10 years later, the county is now coming and saying that this does not comply with the site plan. It makes no sense to us. It is, and Ms. Gore mentioned, you're going to hear a lot of compelling testimony about why this shouldn't, why this should not be a public ingress and egress, and that's true. It shouldn't be, and we don't know why they are relying on this site plan condition to say that folks are in violation. So if you could turn to the next slide. All right, so this is a little bit of the history, the timeline. The site plan was approved in 2003. The deed of re-subdivision that they contend does not meet the criteria of the site plan was issued in 2004. The developer was released from bond nearly 3 years ago. Lot 23 was cited for a zoning violation in October of 2013. And then the developer isn't cited for a zoning violation until 2015. And then what happens in August is they unilaterally remove the bollards. So if you could turn to the next slide, please. All right, so this is a picture of lot 23. You can see the plat there. It shows essentially the driveway and the conditions there. You go to the next slide, please. This is lot 24. This is where lot 24 actually is the one that has the bulk of the driveway portion that they want the public ingress egress on. The developer has no power, nor does the HOA, to grant an easement over this area. Can you turn to the next slide, please? All right, so this is what's happening now since the bollards have been removed. You can start to see that trucks are starting to go through there. You go to the next slide. Now, this is the safety situation that we've talked about, and again, the reason we're pointing this out is not for the compelling reason that, oh, you should do something that you can't do with regard to change the conditions of the site plan. No, it's to point out that this is the way that this was designed back in 2003 and 2004. The fact that there are no stop signs, the fact that there is no signage, the fact that that's a driveway apron, that's the driveway apron that we're talking about between units 23 and 24 that was designed, and the county signed off on that. But this is a safety hazard. This should not be a public ingress and egress easement. So we'll go through a couple more pictures here that will show that. We've had a couple of near accidents already, and Mr. Groharan, who is the representative of the HOA, will get up and testify a little bit more that there have been many more than what we've presented here. Can you go to the next page, please? So here's an example of how ridiculous this is with regard to this being a street. All right, so here's one car, all right? One car that is trying to drive on this. You can notice that the left wheel is on the grass, and it would probably be hard for that car to drive on the two strips really in a way that this would be considered a public ingress egress. And then the other thing is what's going to happen when someone's coming in the other direction because there's no signage, nothing. This is not intended to be a public street. So if you turn to the next slide, please. All right, so here's another accident that just about occurred. All right, so going to the next slide. Again, here's a picture of the no outlet sign that was placed up there. Next picture, please. Here's a picture of a pedestrian nearly getting hit by a car that's going over there because there's no stop sign, who has the right of way, all that sort of stuff. So if you go to the next slide, please. So in conclusion, from my viewpoint on this, we didn't grant that as an easement, and it's true that we did not grant it the developer did not grant that as an easement as for public ingress easement. It was never designed for that. And the site plan condition 15 shows exactly what was intended. It mentions an alley and describes a driveway entrance. There's no mention of this being considered 13th Street or public throughway. The alley is not designed for public ingress egress. As the pictures show, it's too narrow. It can only accommodate one-way traffic, no signage, has a driveway apron. This is a safety hazard, and we have no idea why this is being pursued. Like I said, the parties to the violation, actually 2 of the 3 can't even grant an easement, and the other third, lot 24, can't grant it over the entire area. Lastly, I do need to mention the fact that we believe that from a legal perspective, the granting of the plat and the issuance of the plat, we obtained vested rights with regard to those things. This has now been 10 years since the plat was recorded and the easement was recorded. And for those reasons, we ask that you grant our appeal and deny the zoning violation. Next, Mr. Tom Davis from the developer would like to speak. Unless you have any questions for me before I sit down, I'll probably...
Chairman, I do have a couple of quick questions.
Mr. Smith.
So the last thing was adverse possession. Is that what you're saying, through acquisitive prescription?
Vested rights. In other words, the idea is that because to the extent that there's any change in the county's position, the county's position in 2004 was this was all in compliance with the site plan, and those rights have vested. It's not an adverse possession.
Okay. You don't disagree that the language in the ordinance that was passed and the deed that was recorded is different? It's not identical?
I think that the
It's different language, isn't it?
No, I think that the deed that was granted is consistent with the site plan that was issued.
It's not identical. The language is different. It doesn't read word for word, does it?
I'm not sure which.
Okay, when you look
I
at...
admit that that there is not an emergency a public ingress egress over this particular area. There's no question about that. I mean, and that's a fact.
I'm talking about the ordinance that was adopted on September 16, 2003 at 6:30 p.m.
Right, the site plan conditions.
Yes.
That's paragraph 15.
I'm talking about 46.
But that's part of the same document.
Yes, but that's a different condition. But just let's deal with 46 first.
Okay.
That 46 and the recorded 46 are different. They have the mention of emergency vehicles is in the county ordinance, and it's not included in the...
No, the condition 46 is what I said at the beginning of it says that the emergency egress will be over private internal streets.
Well, let me just read. The developer agrees to grant a permanent public easement to the County Board of Arlington, providing for public ingress and egress, access and use by the public at large and by county emergency fire police vehicles over the private internal streets and sideways.
Correct. This is not a private internal street.
I mean, you don't deny that was a street with houses on it prior to this development.
I do. It was originally an alley.
In 1986, I looked at a house on that street and considered buying it. It was a dirt road, that's true. It wasn't an alley.
Sir, I can show you in the packages that.
Let me then direct you to this. What was recorded is different. That's on page 9 of the deed. Further witness that for good and valuable consideration, et cetera, et cetera. Ms. Kaur read it. An easement for ingress, egress, public utilities, emergency access, storm drainage, et cetera. It doesn't say the public. I mean, it's.
I completely agree that.
But your point is that I know it to be a street, isn't included because it's a driveway.
And that's what
That's your point.
That's the site plan.
Okay.
That's what the site plan.
And you agree, estoppel doesn't lie against the government. You agree with that legal tenet, right?
I do, but we're not arguing a stop.
Okay. All right. That's it. Thank you.
Any other questions for me?
Mr. Melnick?
If I noticed, so you're referring to the area between lots 3 and 24 as a driveway, and saying that it was referred, in I guess condition 15 as a driveway, but it's it looks very true that this easement's nonetheless what appears to be somewhat along the lines, even though not, as we've said, not exactly along the lines of 46, actually the easement for ingress, egress, public utilities, and emergency access. So it looks like somewhere along the line, despite 46, somewhere along the line, the public at large language was deleted. But I just don't, I don't buy into the argument that you're saying it's a driveway, when in fact, it looks like, at least from what the developer wanted to do with this easement, is somewhat on condition 46. So it just that easement's there, missing some elements of 46, but it doesn't look like on the file it was treated like a driveway, just because it has some of the contents of 46, but not the public at large. So I'm I don't think the argument, I don't buy into the argument about it just being a driveway and somehow 46 not applying between 23 and 24. So could you elaborate?
The only thing that is between, you saw the pictures between lot 23 and 24, those two houses. Nothing else, there's nothing else between lots 23 and lots 24. And for you to say that that is a street over which public ingress and egress is required, when condition 15 says you will construct a driveway entrance to the 12-foot wide private driveway between units 23 and 24, you can't read those and reconcile those with calling that a street. And the fact that it was blocked for 10 years is indicative, and that the developer got off of bond without. There's no signage. There's no if you look at the facilities manual and the conditions for it actually being a street, there's no curb and gutter. It doesn't meet the width requirements. In order, at best, it meets the definition of an alley, which is a 12-foot wide sort of condition. So you cannot reconcile those two conditions in the way that the county would. And that's why the plat was issued the way that it was. Nobody else interpreted it that way. We don't understand why 10 years later it's being asked to be opened up as a public ingress egress when it was never intended or designed to be that way. So, any other questions?
I have one follow-up. So aside from the streets that were dedicated for the 13th Street South and the South Kenmore Circle, so aside from those, is there any of these easements for ingress, egress, public utilities, and emergency access that include the public at large or not?
I'm sorry, I don't understand the question.
It seems like every time this easement for ingress, egress, and public utilities and emergency access, none of those areas include public at large language.
There's a different section of the easement that actually does that. If you look at page 4 of the easement, it says dedication to public streets and utility purposes, and that's where the public dedication for the street component, the public ingress egress was. So everything on this particular area, everything that was deemed to be a street to have public ingress and egress is granted the public ingress egress on page 4 of the deed of dedication. And the paces, in essence, so this area, if you look at it, deals with that public ingress egress, and then the rest of it, because it's not full public ingress egress, is covered over all of the different areas. So there was a grant in accordance with condition 46, and then you have to go to the plat and see the different areas on the plat where the public ingress egress was because you can't read the dedication, the site plan goes with the plat, goes with the drawings. So we believe that the developer clearly complied with the site plan conditions as intended, and that's what happened in 2004. So.
One other question. Yes. But isn't an easement's much different than a dedication? So if you're saying that somehow this language about the easement for the public at large is somehow included in the dedication to public street and utilities purposes, because dedication means fee simple to the county, but clearly this is talking about an easement for the public at large, and so, I don't think you can somehow say that 46 is incorporated, even though, since they say easement, that somehow refers to a dedication. So I think they're two separate things.
But if you have to look at the plat also in conjunction with that, and the annotations on the plat as to what was granted and where the different easements were granted. And if you go through the plat and you look at the different areas where it says, easement for ingress, egress, but the various different areas and the different ways that it gets referred to, you have to look at those in that context. And I'll have the developer speak a little bit more towards that as well.
Okay. Thank you.
Not uncommon.
I don't think the county is contending that it's only this area that the county is contending that there needs to be a public ingress egress over as well.
Mr. Chairman?
Mr. Smith?
I think that was kind of my question. How did this come about? You said several times, 10 years later, why is this coming to us now?
Is my understanding what happened was the Lot 23 owner, someone was driving around the bollards, and Lot 23 owner complained to the county about the fact that someone was using this or trying to use it as a cut around, and so
Careful what you wish for.
Yeah, that's.
I got it.
So anyway, so that sparked, my understanding is a review of it, and then we've been doing this for now 2 years.
Let me ask a question. Since we got into all these questions with you, I'll go ahead and ask mine. As a member of the public in general, any one of us, can we walk down this from Monroe Street, down this?
The sidewalk, yes. Yes, the sidewalk there, the brick sidewalk is open to the public.
Is there an easement for that?
Well, he's contending that there is in the language, because he just told me.
Sidewalk, it's public ingress, egress over the sidewalks, and there's a brick sidewalk that goes down that area.
Just read it on here.
You look at, if you go back a couple pictures, you look, there's the brick sidewalk that goes down.
I was actually looking at the easement language. Does the easement language allow public ag?
Yes,
It
it does. It allows it over the internal sidewalks.
And on the plat, it says easement for ingress, egress, public utilities, and emergency access hereby granted in the area in question.
Yes.
Between the two lots.
Yes. And the question is whether that's full public ingress, egress over that driveway area, or whether it's limited.
Shall we move on? Has everybody asked their Questions? We hear from Tom Davis, please.
Thank you.
Good evening, members of the Board of Zoning Appeals. My name is Tom Davis, and I am the Vice President of Engineering of JCE Inc., which is the parent company of Glebe Road LC. Glebe Road LC is a single-purpose limited liability company formed to acquire, obtain rezoning, site plan approvals, and develop townhouses, single-family lots in what is known as Majestic Oak subdivision. I've been involved in this development since the land assembly rezoning stage, but my primary focus of responsibility is with the engineering, land development, bonding process after the zoning and 4.1 site plan approval. Once this 4.1 site plan process was completed, a detailed engineering site plan, including the permit plan submission, record plats, legal instruments, and other associated documents, must be prepared and submitted to review and approval by the various agencies involved with the Arlington County Plan Review process. The process involves overlaying the 4.1 site plan conditions with the zoning ordinance, the public facilities manual, the VDOT requirements, building codes, geotechnical requirements, and all other requirements imposed by various Arlington County departments, including DES and Parks and Recreation. There are total of 52 4.1 site plan conditions which need to be interpreted and incorporated into this process. All aspects of the permit plan review process, including the site plan, plat, legal instruments, and homeowner associated documents, were submitted through the Department of Zoning for the review and checked against these 4.1 plan conditions. The principal reviewer in the Department of Zoning was Clyde Hawkins. Many of the 4.1 conditions contain conflicting language and are generally inapplicable to single-family and townhouse development and difficult to interpret. Condition 46 specifically provides for a methodology for implementation by including the following. The easement shall be granted by deed in form and substance acceptable to the county manager and shall be recorded among the land records of the Circuit Court of Arlington County. The subdivision plat, including all easements, were coordinated with a site plan package with legal instruments, including the deed of subdivision and homeowners documents submitted to and reviewed by the requisite county agencies, including zoning and the county attorney's office as deemed appropriate by the county manager. This process was completed and the record plat and easements as interpreted were recorded. Subsequent to this approval, site permits were obtained, construction completion bond posted, conservation escrows posted, and site development work undertaken. All site development work is inspected by Arlington County zoning and DES inspectors, as individual houses are completed, they're issued individual certificates of occupancy. After the issuance of the final certificate of occupancy for the last home in the Majestic Oak subdivision, final inspections were made of all site improvements prior to the release of the bond. Final bond release was granted in October 2012. Upon release of the final bond and escrow, the job was effectively complete and closed out. At that time, a transition meeting was held with the Majestic Oak Homeowners Association. A resident board of directors and officers were elected to operate that association, and the directors and the officers and directors who had previously been in that role, which were all developer employees, including myself, resigned our post in the association. At that time, and per the association documents, when all bonds are released, the declarant's rights are terminated. We're simply dumbfounded by why the county, 11 years after this plat and easement was approved, 2 years after the release of all bonds, is contending somehow that this should be interpreted differently from the prescribed process. It is also our opinion that opening this road creates a very dangerous situation to the residents of Majestic Oak and traffic along Monroe Street. The developer has no power to grant any easements on the property since our ownership has been terminated and since our ownership has been terminated and all declarant rights have expired, we ask you to grant our appeal and maintain this area as an alley that is limited to emergency egress only as intended. We've stated that the road has been blocked for 10 years. It was required by the county to be blocked during the entire development period because no construction access was allowed. At the time the final houses were occupied, at the direction of the county, we installed bollards. It had to be removable bollards. They had locks, which could be removed by the fire marshal or by any fire or emergency equipment to gain emergency access to the site. That's useful in the situation where, say, an auto accident or something happens on Glebe Road, blocks the other entrance. At least there is emergency access to the site. All primary access is to Glebe Road. Questions?
Any questions for the speaker? Thank you, sir. Aristoteles Kronos. Welcome.
Good evening. Aristoteles Cronus, attorney representing the Lot 23 homeowner who's obviously going to be directly affected by this. Let's make this about the legal argument like the assistant county attorney wants to make it, and let's look at condition 46. Condition 46 specifically uses the word streets and sidewalks. Look at the zoning ordinance. Street is defined as a public thoroughfare 30 feet or more wide. 30 feet or more wide. Contrast that by alley. Alley is defined as a public thoroughfare less than 30 feet wide. And I'll continue with that one. That is usually used as a secondary means of particular access, not intended for general traffic circulation is how that ends. We're talking about a 12-foot wide strip here. This is not a 30-foot wide strip. If you look at what they were intended to do, what they were supposed to do, is put the easements over the streets. If there wasn't a street, they didn't have to put an easement over it. Regardless of what's in the actual recorded easement, and that recorded easement has a lot of different language in there, not just the stuff that the county wanted them to do, but the stuff that the developer wanted for their own residents afterwards. And just for things like utilities, other things in there. So they voluntarily said, this is what we want this area to be, what access we want. And obviously they wanted emergency access from that, but they didn't want anything else. And they weren't required to give anything else per that thing. If we're looking at, it specifically says street, which this case, 12 feet wide, certainly is not a street. You're looking at this from the condition of, we're now looking at this 10 years later. Interpretation was made, it was adhered to, it can't be changed now 10 years later. That is a vested right that has to be adhered to. There has to be some finality to these projects. Thank you.
Thank you. Adam Henderson.
Good evening. My name is Adam Henderson. I am chair of the Pike Presidents Group, and since 2013, I've been the president of the Douglas Park Civic Association, where this property is located. Although the construction of Majestic Oaks predates my time as president of Douglas Park, it does not predate my involvement in the Douglas Park community, where I've lived for the past 17 years. I'm in regular communication with the former officers of the association, including Rebecca Kraft, who was president of the association at the time Majestic Oaks was built. The consensus of the association and its former officers is clear. The alley in question was never intended nor built as a street for regular access by general vehicular traffic. Had this been the case, the association would have vigorously opposed the street from the outset, as it would have served to provide yet another neighborhood cut-through for commuters frustrated by backups on Columbia Pike and South Glebe Road. It is also disturbing the county staff found it appropriate to remove the bollards under dispute while the matter was under appeal before the Board of Zoning Appeals, and without prior notification to or discussion with either the Civic Association or the Homeowners Association. Actions such as these serve to undermine the confidence of neighborhood residents in the county and the fact that they will listen to their concerns and deal with issues in a fair and responsible manner. The end result of the barrier removal on 12 August 2015 is the county has, by its own action, created a major public safety issue for neighborhood residents by forcibly opening a roadway that is not designed for vehicular traffic, has poor sight lines, and is dangerously close to occupied properties. This action has also subjected our neighborhood to more cut-through traffic that formerly and more appropriately would have been confined to the major arterials. The Douglas Park Civic Association urges the Board of Zoning Appeals to reverse the decision of the zoning administrator and to maintain this alley as it was designed, as a driveway for egress and ingress for emergency and public safety vehicles only. We further urge the county staff work with both the Douglas Park Civic Association and the Majestic Oaks Homeowners Association to develop a reasonable solution to this issue to both preserve public safety and protect the safety and character of our neighborhood. Thank you for your time.
Jeff Grohering.
Good evening, members of the board. My name is Jeff Grohering. I'm the president of the Majestic Oak Homeowners Association. We very much appreciate your time and attention that you're devoting to an issue that's of utmost importance to the members of our community, both our association as well as our surrounding neighbors in Douglas Park. I want to talk to you just a little bit about Majestic Oak as well as the impact that removal of the bollards has had on our community. We are a subdivision comprised of 24 homes, a very small subdivision, and many of which have young families. We have well over a dozen and counting young children that play in the area of Majestic Oak, and you saw from the slides there's a common space where many of our kids play, and up until early August would ride their bikes on the streets within the community. That has stopped. We, as residents, are at a loss to understand how we got to where we are right now. We all purchased our homes with the understanding from looking at county records that this would never be a street that could be opened to the public. The property was developed that way, it was marketed that way. We all relied on that information and purchased our homes in what we thought would be a safe community, not present with the hazards presented by now a street that is certainly not designed as a street, but now being used as a street. So it's been most frustrating for us. What I will say is we remain open. We've been open since the first violation was issued to work with the county on an appropriate solution. It was originally described to us as a safety issue for emergency vehicles to enter or leave the community. At the beginning, it was not even contemplated that this could be a public access via that road. So to the extent it is an issue with emergency vehicles entering and bollards are a problem, we remain willing to work with the county on that issue. I only have a little bit of time. You saw some photos in the presentation. That was just a handful of photos that we've taken over just in a matter of a few weeks since the street now was opened up, what used to be an alley. We have daily cars now zipping up and down that street. Delivery trucks now using it as a cut-through, and it presents a significant hazard, not just for our community members, but for folks who use that sidewalk. You can tell, and there's a picture that's very poignant in there of a woman who's carrying a child and pushing another child, and she came within feet of being run over because of the county's actions for removing that bollard. That type of thing happens every day. And I just want to finish by saying I get photos almost every day from members of our community saying, here's another car that is coming through. Here's another incident. Here's another brake screeching incident where two cars were coming opposite directions. We appreciate that the county has an interest in wanting to have emergency access. We're willing to work with them in that regard, but we think now, by removing these bollards, the county has presented a much more dangerous situation, and it's only a matter of time until someone gets seriously injured unless the street is used as developed and contemplated by the community. So we do appreciate your time.
Thank you, sir. That was our last speaker.
I know.
Go ahead. Mr. Melnick?
In crosswalks with
So this is a question for staff. So we've heard from the speakers that they're saying that these areas where the easement for ingress, egress, public utilities, and public access, that these areas are not really streets, that they're driveways. And it's true that condition 46 refers to a street. So what is the county's response, or what is your argument that these in fact should be considered streets as set forth in 46 instead of a driveway, something not considered by 46?
I just passed up the board report that went along with the site plan that was approved in 2003. And the reason I did not originally attach this as part of the staff report is I do think the site plan conditions speak for themselves. However, the board report does provide some valuable background information, especially regarding the difference between a street and an alley and whatnot. So if you turn to page 6 of that board report, well, first of all, I should say that county staff in 2003 did not recommend approving this site plan. The recommendation was for denial of it. And one of the reasons was because certain streets were not built to be streets. So on page 6, if you look at the second paragraph down from the bottom, it specifically talks about the driveway, alley, whatever you want to call it, between lots 23 and 24. It says the internal streets are typically 23 feet wide. A private existing alley between the two existing houses fronting South Monroe Street is 12 feet in width with two-way traffic. The alley cannot be widened without removing one of the existing houses. Staff is uncertain of whether the alley could function as a two-way road after the project is built. So before it was built, it was indeed a driveway or an alley, whatever you want to call it. The developer has agreed that the county manager may require that the road be converted to a one-way alley if at a later date staff concludes that the road is causing unsafe conditions. And that is actually incorporated in condition 50, which is an option for the developer at a later time to convert this road into a one-way street. But continuing on, it says in the next paragraph, the private streets in this development will be those adjacent to, and it lists townhouses 19 through 22 and single-family units 4 through 10, 23, and 24. So it defines the road between 23 and 24 as a private street. It then goes on to say the private streets will be owned by the homeowners association with a public access easement. So that is incorporated into condition 46, which talks about how the private street will give us, the private streets will be conveyed with a public access easement over them. And then as far as the question over, who has authority to grant these easements, I've attached the declaration documents with the staff report, and there's a citation here that it clearly reserves the general right to the declarant and the homeowners association to grant an easement over the common areas. And the common area is also defined in the declaration documents as any area over which there is a easement for emergency access. So, contrary to what's been claimed, the declarant and the homeowners association retains all rights over the easement area, and they can grant the county that easement that's requested. So the reason why condition 15 says that the declarant, the developer, I should say, has to build a driveway between, it actually is a driveway entrance, is because we intended for people to enter that street because it's supposed to be a street. Now, staff does recognize that it's unclear whether it could function as a street. That doubt is in here, which is why the option is retain in condition 50 to convert it to a one-way street. But it's also clear that that it's defined in the staff report as a private street. The alley, the driveway, whatever you want to call it, between 23 and 24 is defined in here as a private street. And the action adopted by the board says that the developer has to grant us a public access easement over all internal streets. This is an internal street. So the fact that it's called a driveway in some areas, it's just a recognition of that's what it was before it was built.
Ms. Freshman?
So is it your position that, contrary to what we've heard, that the HOA has the control over the easements and therefore would have standing to apply for a site plan amendment?
Yes. Yes, and I can actually direct you specifically to the section in the declaration document where that is. It's about 2/3 of the way through the packet. There is a page 16. It talks about easements, section 8. And section 8, subsection 1, says the declarant and the association reserves the right and easement to the use of all common areas, and any lot or any portion thereof as may be needed to repair, or repair, maintenance, or construction on such lot, blah, 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 or bond release. And then it also says, under section 3, there's a blanket easement. An easement is hereby retained in favor of the declarant and the association over the lots in any common area for, it lists, cable installation and other things, but it's further granted for the purpose of, I'm sorry, maybe
Even in this next section, pedestrian access, talk about internal streets.
I'm sorry, I didn't read the full sentence. It says, an easement is hereby retained in favor of declarant and the association over the lots in any common area for installation of trails, landscape, and construction of a common area cable system, a common sprinkler entrance or features, or any other item for the common enjoyment and or benefit of the owners. Now, in this case, granting the county an easement is for the benefit of the owners because otherwise the entire subdivision is in violation of the site plan. And the only two parties that have the rights to do so are the declarant and the homeowners association because they're the ones who have this blanket easement reserved to them. We've searched the land records. I have not been able to find, and I have not received from the declarants any documentation that these rights have been extinguished or conveyed out in any way. And further, we actually also have easements granted to the county by the developer and the homeowners association for other things, but in the common area that's contemplated.
Thank you.
Any other questions?
Does anybody have any questions of the applicant or the staff?
I would, Mr. Chairman, I'd like to hear Mr. Bircher. I'm sure he's reviewed this and have a reaction to specifically what Ms. Kaur pointed out on page 6.
Page 6 of which?
Of the staff report from 2003, the September 9/11, 2003 staff report.
That was not something.
Don't have a copy of this? You've not seen this?
No, I just passed it out to you. I have a copy here from Mr. Bircher.
I would just say that the staff report is a staff report, and this sets, the fact is that the site plan is what was approved. And to go back and pull out various different versions of staff reports.
Oh, legislative history?
But it's not binding. The binding part is the site plan and the site plan conditions and the language of the site plan. To pull out things, if there were times that we could pull out the staff report and tie that, I don't think that they would allow it in the same way that they're using it.
But the bottom line is, I believe, I believe they're using it to persuade and to provide some background in terms of how you got to the ordinance and what was staff actually recommended and what issues they pointed out. I think it would be helpful, obviously, if you saw this paragraph.
I have a copy for you if you'd like.
It's on page 6, next to the last paragraph. Paragraph that starts, the internal streets are typically 23 feet wide.
It starts out with saying a private existing alley between two existing houses fronting South Monroe Street is 12 feet in width.
With two-way traffic.
But it refers to it as an alley. The site plan requires only public ingress egress over streets.
But it goes further. This paragraph goes further. The alley cannot be widened without removing one of the existing houses. There's a house on this alley, a little blue house, one story, about 600 square feet. Staff is uncertain of whether the alley could function as a two-way road after the project is built. The developer has agreed that the county manager may require that the road be converted to a one-way alley if at a later date staff concludes that the road is causing unsafe conditions. So this seems to imply clearly to me that staff was contemplating that it would be made a road and there would be a testing period, and if it didn't function, it would revert to an alley. I don't know. I could be reading it wrong, but that's what it seems to suggest to me.
I understand that this staff report is dated September 11th of 2003, and what was actually approved by the board was September 16th of 2003. It's 10 years old. I wasn't involved in the project.
Right.
I can't connect
No,
the
I
dots.
understand.
The person who did that from our firm is no longer here. But the fact is that it was never referred to as a street in any of the documents. And I'd also like to talk a little bit about the idea that these folks have the ability to grant an easement. They don't, and I disagree with...
Nunc pro tunc?
No, you can't.
Now for then?
No, you can't. You cannot go back. Okay, there's a basic premise of law that says that someone who owns an easement cannot expand that easement or grant somebody else an easement. Okay, so, and Ms. Gore keeps referring to the common area. This is not the common area of the property. There are a couple little out parcels that deal with stormwater management, that sort of stuff, but there is no grant. As I pointed out in the plats, which you have in our exhibits, that area is over the different lots, and those have been conveyed without this, and there is no ability for us to go back. It would be a void. It would be a void grant of an easement, and so the idea that we can do that. This has got to end. The declarant this has been off bond for a long period of time. This is an old subdivision. We think that you really ought to deny or grant our appeal and deny the fact that this is considered a zoning violation and put an end to this. We'll work with the county in terms of figuring out the right process for the emergency ingress and egress and what's an appropriate way to make this safe. But this really should not, the first kernel in this is for you all to consider that this is consistent with the site plan, and therefore...
Chairman, one more quick question. Well, if that were true, if the county just dropped it, what would prevent the HOA from putting the bollards back up with the lock? What would prevent them from doing that?
Well, the issue with regard to that is whether or not the bollards are a reasonable restriction consistent with their emergency ingress and egress. And that's a debate that we've had with the county, and we will continue to discuss it with the county and come up with an appropriate solution. For 10 years, and when this development was created, the county considered that acceptable. It wasn't until somebody else came back and reviewed it and changed their mind that it wasn't acceptable. I mean, the county actually made us paint those bollards to get off site.
I kind of heard you say nothing really, except we could then discuss whether it was reasonable or not. But I mean, I think they've been found over time that a lock with emergency access to the key is a reasonable access.
The county rejected that in our negotiations.
I can appreciate that, but I mean, what would prevent the homeowners from putting those bollards back up?
Well, that's an interesting question, because that zoning violation issue, I honestly think is part of this appeal. I mean, these appeals were all together. Lot 23 is not appearing here, but these zoning violations were issued in 2003. The developer and the HOA were included in 2015, but this exact same appeal was done by the Lot 23 owner, and there were two other violations related to the bollards, and it was basically said either submit a site plan amendment or remove the bollards. We went through negotiations and all that sort of stuff, and we're here today because for whatever reason we can't come to an agreement on that. But really, there needs to be some sort of restriction on this. As you can tell, it is not designed, and I don't think the county, when you ask that question, it would denies that this was not designed as a street. And if the BZA grants our appeal and contends that this is not a zoning violation, that will end the issue unless they appeal, obviously. But and then hopefully we can go back and work on an appropriate form that makes sure that this says that it's emergency ingress, egress, and deal with the safety issues as a result of the removal of the bollards. Thank you very much for your time. Unless you have any.
Do you have a question for him?
No, I have no questions. I was going to. Okay.
Stand by. I will.
Okay.
Go ahead.
No, if you have questions, if we're still in the question
for you.
period.
Sir.
When there is a way to, as the Neighborhood Association president mentioned, work with the community, work with the staff, and that being a site plan amendment, why hasn't that been pursued?
The site plan amendment hasn't been pursued because of the bollard issue. We basically told under no conditions will bollards be issued, and we really never thought that this ingress egress issue was ever something that it was like the tail wagging the dog. This was a sub issue to all of these. Let
me just. I apologize, but let me just stop you. You can request a site plan amendment to make this condition anything you request it to be, and the county board turn around and approve it. So they could approve bollards, they could approve closing it down, putting a wall across it, taking it out, or whatever. That struck me as being the remedy to this issue that might actually get Majestic Oaks what they desire, or the homeowner in question. Majestic Oaks is a civic association, and it sounded like to me from the testimony of the neighborhood what the neighborhood would like, and make it clear to everyone. A rewritten condition 46 that straightens this all out.
I understand, and I think that we are in compliance with the site plan, and that's unnecessary. It's a cost that these people are going to have to go through. It is time, and it is, we are in compliance with it is our position that the development is in compliance with site plan condition 46 as well as site plan condition 15 and in conjunction with it too.
Thank you.
Thank you for your time.
Mm-hmm. Anybody else? Oh, Ms. Malice.
I have no more. I want to move this forward.
Okay.
If anybody.
There's no more questions with the board. Is there a motion?
Mr. Chairman, I appreciate the complexity of the situation and the twists and the turns and the deep concerns of the neighborhood and the homeowners, but I go back to what I understand our limited ability, our limited charge here is, and that is whether or not the zoning administrator correctly ruled when she cited this incident. And that ruling is based on the site plan conditions that are in front of us. I wish that we had the power to negotiate or to find a remedy here. But I don't think that is within the power of the BZA. I do think clearly it's within the power of the county board who wrote these site plan amendments. And it's a forum that lets community members and homeowners and all interested parties engage in a process to come to a mutual decision. But we have a lot of parties that are not in the room here that if we were trying to craft a final solution, we'd want to hear from. We'd want to hear from the emergency response people. We'd want to hear from other neighbors. This is just not what we are geared to do. If I understand, our mission is simply whether or not the zoning administrator made the correct ruling. And for that reason, I would like to move this forward with a motion that affirms the zoning administrator's ruling, and then we can discuss whether we're all in agreement with that. So I move that whereas the Board of Zoning Appeals has held a duly advertised public hearing on September 16th, 2015 on case number V-11026-15-APP-1, an appeal of the zoning administrator's determination that the language of the easement does not convey the rights required by condition number 46 of the site plan number 373, and whereas the BZA finds that the zoning administrator's determination is valid and correct, and now therefore be it resolved that the BZA hereby affirms the action of the zoning administrator in determining that the language of the easement does not convey the rights required by condition 46 of the site plan 373.
Second.
Motion has been moved by Ms. Malice and seconded by Mr. Smith. Is there any discussion or comment from members? If not, all those in favor say aye.
Aye.
Aye. Opposed? Carries 5-0. The zoning administrator is upheld.
Right. This brings us to our next case tonight. This is V-10984-15-UP-1. It's a carryover and revised use permit request by Daoud Majahidi and Maria Maldonado to permit a setback of 5.6 feet to the wall of the home from the left side property line instead of 8 feet as required, 7 feet to the home from the right side property line instead of 10 feet as required, also an aggregate side yard of 12.6 feet instead of 18 feet as required. It's for the construction of a new two-story home. It's in the R6 zoning district on a premises known as 2105 North Emerson Street.
They're not going to do that. They're going to apply for a site plan amendment. Any questions for the staff on this item? If not, could we hear from the applicant, please?
My name is Nelson Maldonado. I'm here representing the owners. We were deferred last time and requested that we reach out to the Civic Association for this issue that we have. Unfortunately, we reached out to the Civic Association and they we emailed them. We did not get a reply from them for, I believe, about 2-3 weeks when we ended up sending a certified letter to them requesting for a meeting. And we were told that they would not meet until the end of this month. And they suggested that we send letters out to neighbors to a broader geographical area of the property. So we did that. We sent 215 letters out to neighbors, and we received 33 letters back from them supporting the construction of this new house. And we got 5 letters that do not support the construction of this house. We also had a meeting at the request of some of the neighbors last week where a lot of questions were asked, and we tried to answer as much as possible all those questions. And there was one request that we move the driveway to the opposite side of where we currently have it. And I have a site plan that shows that we were not able to get it in the package that you guys have there, but I can provide that site plan.
That conclude your?
5 copies, yes.
Okay, well, let's see if the, just give those to me. See if the, okay. Do board members have a question of Mr. Maldonado? If not, then I'll call the next speaker, Sean Martin. Welcome.
Hi, thank you. My name's Sean Martin. I'm the owner of the property immediately to the left, and I'm here to express that I do not agree with the current plans as submitted. My concerns are the driveway, the trees that would be impacted on page 3 of the material presented tonight. A third of the way down, it says the proposal would not affect natural landform, historic features, or significant trees. I do believe there are a number of trees on the property that would be impacted. I believe the approvals that are submitted, that neighbors have support of the proposal, they're not fully informed. The material that I've seen that was sent to the neighbors don't have all of the drawings, don't show the driveway, don't show the setbacks. They have plans of the building, so they're drawings of what the structure will look like, but they're not a full set of information that's been presented here at the June meeting. And I have requested that the driveway be moved. I've not seen what the new plan would be. An arborist plan be put in place so that the neighbors, we could feel comfortable with the trees that would not be impacted. Reduce or remove the eave on the left side of the property. Right now it's 5.6 feet setback from the property, but the eave is only, I believe, 5 feet setback. And that landscape plan be shared with the neighbors. That may or may not include a privacy fence since the structure is so close to both property sides. And that the construction equipment be limited to the front of the lot. The back has an alley that's owned by someone on the street behind us. It's a grass lot, and when the construction was done a few years back, the access was used regularly, even now. I'm pleased to say they have been cutting the grass, and I'm thrilled with that. So we're have seen some progress. We did request a meeting last week, and we're pleased that we have opened a dialogue with the owners, and so I'm looking forward to continuing that dialogue.
Thank you. Last speaker is Willie Jackson Baker.
Good evening.
Welcome.
My name is Willie Jackson Baker. I live at 2106 Emerson Street, which is diagonally across from the property. And it has been in this condition for 2 years, an eyesore, and the community is quite tired of how it looks. We would like to see something built on its site, but it should be something that we can all live with. Recently, there were 6 neighbors of the 2100 Street block that met with the representatives of the owners to clarify some of our concerns, and Sean and I are here to represent those 6 owners tonight. The packet the community received and that the neighbors were asked to respond to only shows the dimensions of the property, of the dimensions of the house, not property lines nor explanations of what variance is needed and why it's needed. It did not include a critical diagram, and that is the one that's included in the county packet that shows the driveway. This diagram of the driveway to the right of the property, we were told had been mandated by Mr. Noxon. So in that case, we asked that they at least move it to the left side of the property where it would not be 3 feet away from a house. I personally would like to see it on the rear of the property. Also, if a second story is added, which is in the plans, it would require moving some trees or partial removal of some trees. Even moving the driveway to the left side would require moving of some trees. And we were not satisfied with the explanation that the representatives gave us about that. We would also like to request, if possible, that all construction vehicles and equipment enter the property from the rear and not the front side. It's already a very congested street. So we do thank you for hearing us. You know, we've been here for quite a few years, and we do thank you.
Thank you, ma'am. That's the last speaker. Any questions from board members?
Mr. Chairman, I wonder if Mr. Martin and Ms. Baker have a copy of this new plat showing the driveway on the left, and if not, if they could be provided a copy, maybe by the applicant. I think your neighbors might want to see this.
Do you have additional copies? They can have my copy.
Yeah, mine too.
Do board members have any questions for anybody?
I have a question for the applicant's representative. The concern about the trees and access during construction, can you grant what the neighbors have requested, that A, you enter from the rear for construction, and B, that you preserve the trees to the extent that you can?
We do plan on getting an arborist engaged in this process, as it would be part of the package that will be submitted to the county for building approval for the building permits. So there will definitely be an arborist involved in it, and they will make the recommendations as far as the trees removal and replacement. And we are willing to work with the neighbors, and as far as the trees are. As the gentleman mentioned, the back alley is a private alley. If we can get permission from whoever owns it, we would be more than happy to use that back alley.
Anything else?
No, none of the applicant, thanks.
Do I have a motion?
I have a question of staff, though, Mr. Chairman. The plat does show the alley as being private. Who's the owner?
I can't remember if I put it in the report or not. I know it is about 3 houses down on, it's the street behind this one. So let me see where the map is here real quick. It's an owner on Edison. I can't remember if it was 2116 or 2112. It's one of those two that owns the alley.
And it runs, where does it stop at that? How far does it go?
To the back of 5110. Looks like.
Okay, that's a better map, yeah. So you said the owner of 2110 owns this alley?
It's 2110? 12.
Oh, 12.
Mhm.
Okay. Wonder.
We can't condition the use of somebody else's
You
property.
can't condition the use of private property.
Somebody else's.
No, no, you can't do that. That's very interesting that they own they own that whole area. That's interesting. Okay, well,
I have a motion, please. Mr. Milner?
All right. In case number V1098415UP1, I'll make a motion that the Board of Zoning Appeals approve of this request as advertised in the attached resolution with the conditions stated on there.
Is there a second?
Clarification?
Can we reference this, the revised plat?
Is this the motion to adopt the the staff's recommendation?
Exactly. It's because they recommended approval, so it is the resolution to approve.
But can we reference the revised plat with the driveway? And while we're at it, encourage the use of the alley, privacy fences, and protecting trees?
Well, I didn't
Just a thought.
address it. So I didn't address that because it was a private alley, and also I noticed that it looks like the trees are right where pretty much the house is going to be. So I didn't think that was feasible. So it's just a plain motion to adopt.
Is there a second?
I will second.
Well, Mr. Chairman, my only comment is that looking at, can we have one of those construction pictures up? I think it's number maybe 18. Yeah, or so that's a perfect picture. That the foundation is there. It looks like that it might take some trimming, but the tree is already, it exists. They didn't have to take it down, and the pine in the back is also there. So I guess my inclination would be to add some condition that, A, the driveway be placed as reflected by the plat provided today by the applicant, and that that an arborist be employed to determine the feasibility of preserving the trees and or if not replacing them with suitable replacements as mature as possible.
Are you asking for unanimous consent?
Well, I'm asking the maker of the motion and the person who seconded it if they would consider amending their motions to that to include those conditions.
Yeah, I'm glad to include those in the motion about the driveway and the arborist, determining the feasibility of preserving the trees. Yeah, I'm fine with that.
A motion has been made and seconded, and with additions by Mr. Smith that I believe is on the record. Ready for a vote? All those in favor say aye.
Aye.
Aye. Opposed? Motion carries 5-0. Use permits approved.
Work for this one.
Next case tonight is V-11027-15-UP-1. This is a carryover from 2 months ago. This is a use permit request by Michael Jolly to permit a setback at 19.8 feet to the stoop from the North Kensington Street right-of-way instead of 21 feet as required. This is just for the construction of a new open front stoop. It's in the R6 zoning district on the premises known as 878 North Kensington Street.
Any questions for staff? Can we hear from the applicant, please?
Hi, my name is Brian Rosenheim. I am the agent for the applicant. I have nothing to add to the staff analysis or the resolution. I think it's fairly straightforward.
Yes. Any questions by the board or a motion?
I believe that the reason for the deferral was neighborhood outreach, and you've done that.
Signatures from all of his surrounding neighbors.
Excellent. I move the Board of Zoning Appeals adopt the attached resolution approving use permit V-11027-15-UP1, subject to conditions in the resolution.
Second.
Motion's been made and seconded. All those in favor say aye.
Aye.
Motion carries.
Thank you.
Next case is V-11045-15-VA-1. This is also a carryover. This is a variance request by Army-Navy Country Club to permit a protective net and poles with a height of 55 feet instead of 35 feet is permitted. It's for a new protective net for an existing driving range. It's in the R6 zoning district, premises known as 1700 Army-Navy Drive.
Do you have any questions for the staff? Could we hear from the applicant, please?
Thank you, Chairman Russell and board members. Good evening. My name is Andrew Painter with Walsh Colucci for the applicant. This is a very simple request that would vary the height limit in the R6 zoning district as it applies to this property from 35 to 55 feet for a 400 linear foot section of a containment structure, which is basically safety netting surrounding the existing golf driving range. I think you all know where the property is, surrounded by 16th Street and homes which front on to the north, 18th Street to the west, and 18th Street to the east. With a golf course in a rapidly urbanizing community, Army-Navy has had to struggle with how to continue a use which has basically been in existence for almost a century, while addressing the needs of neighbors that have come to this property or located within the vicinity of it. And if you've been out there, you know that one of the changes that Army-Navy made during the last go-round of renovations to the facility was to move the tee box of the practice facility 70 yards to the interior of the facility. And I don't have a pointer with me, but the star is where the tee box sits right now. It used to sit 70 feet to the left of that, a little bit further in. Right there before the renovations took place. And the reason that they moved it in was to address some of the concerns from the 18th Street neighbors. And I'm happy to say that that pretty much solved the issue as far as errant golf balls leaving the property. Concurrent with the moving of the tee box, the club did extend the safety containment structure all the way around the practice facility. And this containment structure, if we can go to the next slide so you can see what it looks like. If you've been out there before, and I'm not a golfer, so this, I'm learning all of this nomenclature for the first time too. But if you go out there, this is what the structure looks like. It's 35 feet tall. It was approved by the county as safety netting. It is a structure. It's located out of the setback area. And the purpose of this, obviously, again, is to keep errant balls from leaving the property. It's recently come to our attention, though, we can hit the next slide. It's recently come to our attention that because, back one please, that because of the higher volume of use on the property, we have golf balls that are still leaving the property and going into the backs of homes but this time for the 16th Street neighbors. And the reason for this is pretty simple. In the area that's highlighted in red there, that's where the balls are kind of cutting off to the right. There is a topographical feature. It may not be big compared to other topographical features in the county, but certainly if you look at the staff report, it talks about the undulating hills and terrain of this part of the county. There is a drainage basin, basically the start of a ravine, right where you see the red, the red highlighted area. And as you can imagine, those 35-foot containment structures, those poles, track with the topography, and naturally they go down and go up with the undulating terrain. And what we are seeking to do, if we can show the next slide, what we're seeking to do is to raise the height of the structures 20 feet, again from 35 to 55 feet, only in the area where it dips down. It's about 400 linear feet. And as shown in this diagram, you can see the existing poles highlighted in yellow, and then you can see the addition that we are proposing highlighted in red. And when we took this idea to the zoning administrator, her response was kind of twofold. One, even though we read the zoning ordinance to say that she has the authority to approve an administrative height increase of this nature, she said that we can't do it. And we actually have it in writing that she says that she does not have the ability to do it, and that our only option was to come to the BZA for a variance. So we are trying to be proactive. This is not in response to a violation or anything. The second thing that she suggested was that we raise the height of the land by constructing a 20-foot berm. So raise the height of the land for the 20 feet that we want, and then put the 35-foot poles on top of the berm. We looked at that. We hired an engineer to take a look at it. We looked at we hired a cost estimator as well. And I think if you can go to the next slide. This is the containment structure that's on the left. That's the area that we would be raising the berm. The homes along 16th Street are on to the right, and you see that foliage there. We looked at this, and we find that the raising of the berm would be at a tremendous cost, several $100,000 to the Army-Navy Club. It would also have, equally important, an unreasonable impact on the neighbors. Not only would it reduce the size of the practice facility, but equally important, we are talking about constructing a 20-foot earthen berm, basically an earthen wall that would have a major visual intrusion upon neighbors. All of the trees that you see there to the right, or between the homes and the existing containment structure, would be gone. That's vegetation that provides very good screening. It also provides additional protection from balls. And equally important, the berm would alter the slope and render the existing stormwater management structures that we have on the property completely useless. And we spent about 18 months with DES trying to hammer out what the drainage system would look like. What we found, though, is that even if we had a berm on the property, even if we raised the berm and stuck the 35-foot poles on top of the property, the height of the poles, where they would top out, would be exactly the same height as if we just had the ability to increase them. But what the fence height allows us to do is to not have the need to construct the berm, not have the need to incur this cost, and not have the need to remove the vegetation. If you go through the staff report starting on pages 2 and 3, there are certain criteria that must be met in order to grant a variance. I want to be very clear here. The hardship here is not that the applicant is seeking to construct an additional fence height. That's not the hardship. The hardship here is that we have a topographical feature that forces the poles down. And when you impose the 35-foot height limitation, it does not allow the containment structure to function the way it is supposed to function. These containment structures are part and parcel of recreational uses. They're found throughout the county. And we do think, and I could go through the criteria if you like, but we do think that we meet them. In conclusion, Mr. Chairman, I would just say that Army-Navy has tried to be a good neighbor. We are proactively seeking to respond to comments that we've received from our neighbors. And I'm not a golfer, but it certainly does not take much to see that this facility serves a good purpose, not only in meeting the athletic needs of Arlingtonians, which many of them use this, but it also serves significant open space and scenic recreational amenities for the county too. And the variance application before you is a simple request. It alleviates a hardship that was not created by the applicant in what we think is the least obtrusive means possible. And it is consistent with the zoning ordinance. And I would also conclude by saying that this application is supported by the Arlington Village Courtyard Condo Association as well as the Columbia Heights Civic Association. And I believe this afternoon we submitted to Mr. Noxon a letter from the Columbia Heights Civic Association, which may not be in your staff packet before you this evening. With that, I'd be happy to yield the floor, answer any questions, and we have the whole expert team here if we can answer questions about the berm or about the containment structure or anything like that.
Mr. Melnick has a question.
Good evening. Part of the staff report addressed the issue with variances of hardships being created by the applicant, and they mentioned the tees being moved to higher ground, and they were saying that goes toward the applicant creating a hardship, making the tees higher, therefore balls, are higher, and the net needs to be higher. So how do you address the whole tees being moved and how that is not the applicant creating the hardship?
Well, again, it's the topographical feature of the land, which is the ravine, which is the hardship that we are seeking to redress. It's not the creation of the additional fence height, which is what the staff report says. It is the topographical feature. And the applicant did not touch the topographical feature when it moved the tee box back. It didn't touch the topographical feature when it installed the existing containment structure several years ago. So it's the topographical feature that is the hardship that we're seeking to redress with the additional height of the poles. And I would say, too, that, we have done everything we can as a club, or Army-Navy has, to address the issue of errant balls leaving the property. They extended the netting precisely in this area for this reason. They took away tees from the practice facility, which makes it much harder to get higher flight balls. They use low flight balls as well to make sure they don't go as far. And the volume of customers is what is resulting in the higher balls, or the higher number of balls potentially leaving the property. And I think oftentimes when applicants come before this board looking for a variance, sometimes they are looking to correct a zoning ordinance violation. That's not the case here. But again, the hardship is the topography of the land. And however small it may be, it still is a hardship that does not allow the containment structure to do its job.
Army-Navy says that if the height increased to the tees, it was very, very marginal. It was not significant. So the tees have not been raised significantly since the new tee boxes were put in.
Okay, thank you.
And for the record, that's Martin D. Walsh, Esquire.
Mr. Chairman?
Ms. Malice.
I was with you with all your arguments until we got to the who created the hardship situation. I mean, it's true that the topography here doesn't work in your favor, but the entire site is usable. You know, your entire site, you're talking about one small portion of your site is having a hardship. But the variance that we're asking for really is talking about whether this limits the use of your entire site. And your site seems to be working as a functioning golf course overall. And if I understand, you actually did move the practice tees from a different area. So I understand exactly what you're arguing, but the hardship is for the entire site, not just for the fact that there's a dip in a particular place, because we could all sort of configure our properties, you know, to create the most adverse situation that we could. So I think Mr. Walsh wants to weigh in on this.
Ms. Malice, I grew up in Arlington. I played Army-Navy probably when I was like 13 years old. I went to O'Connell, our golf team practiced there and in Fairfax. And they had 36 holes and serve a large membership that really exists all over the world. In order to accommodate the driving range has been in this location since I was 13 years old, so it's been there a really long time. But there's really no other place when you accommodate 36 holes for the large membership at Army-Navy to put the driving range. And we think this is the ideal location. We have not received, in my opinion, a great number of complaints from our neighbors on the right, as you see here. And we thought in creating the netting, it was really a win-win-win for everybody. It's invisible. It's not seen from any surrounding roads. It's really a good screen for this purpose. And as Andrew said, it's only like 40 feet in length. So I would say that Army-Navy's taking this thing on as a good neighbor because they're going to spend the money to improve it. They're spending the money for Andrew. And I think that they're trying to do this as a good neighbor. And I think if the Board of Zoning Appeals in its wisdom decides that it's not appropriate, we'll go to the community and say, we did our best. This is the right forum, I think, for this kind of an appeal. And if we're not successful, then we respect the BZA's decision.
I think my issue is not whether what we're talking about is reasonable or unreasonable from a practical standpoint, because clearly from a practical standpoint, building a berm and placing a fence over it versus just making a taller fence has the net effect to properties outside of this site. My question that I'm working through really is from the zoning point of view, what our bar is in terms of determining what a hardship is when a variance is granted. And the practicality is very clear on this. The question is, what is our obligation as far as variances go?
And I think the problem with your question from the Army-Navy standpoint is that they'd have to alter the course and probably eliminate holes. And they've had 36 holes for a long period of time. It's really needed for the play and the membership. And the other thing I would say is driving ranges have become an athletic activity. It used to be you'd go to the driving range, pound about 10 balls, and go to the first tee and play golf. Now people come only for the driving range as an activity center. So it's taken on a little more serious characteristic than it was when I was 13.
Did I misunderstand? I thought you made a change in the configuration of the driving range.
The driving range was moved towards the old clubhouse, and the reason for that, as Andrew said, was there were people hooking balls to 18th Street, and we got a lot of complaints from those neighbors. So in moving it back, we eliminated the problems on 18th Street, and we now have problems from our 16th Street neighbors. They're not as frequent as the 18th Street neighbors were. The other thing is, you can see, we do use dummy balls that don't have the flight characteristics of a normal golf ball, so they don't go as far. But there were also potentially some concerns with new drivers and stuff of people, hitting over the far side of the range. So moving it back makes that virtually impossible. And there's a berm that goes up at the end that sort of discourages that as well.
Okay, thank you very much.
Golf lessons. Any questions for Mr. Painter? Then could we hear from Ron Haddocks?
Hello, I'm Ron Haddocks, President of Columbia Heights Civic Association, and we met with the gentleman here and with the neighbor who was affected by the ball, and I think putting the net up would be the fastest and safest thing for our community. And like you said, you can't see the actual net. We looked at the net, and she's the lady there, which I'll talk to you next. She's the one that affected, but for safety and health reasons, I think we should approve this variance as soon as possible before somebody gets hurt.
Thank you. Ann Call.
Hi, I'm Ann Call, and I'm one of the neighbors that are being affected by the golf balls. I live in Arlington Village Courtyards, and that's on the south side of the Army-Navy Country Club, right next to the fence at the driving range. For more than a year now, our community has been experiencing golf balls being propelled into our area. It is a particular concern in that they often come over with such velocity that they not only come into our backyards, but also over our buildings and into the front courtyards. We have young children and toddlers trying out their legs up and down those sidewalks closest to the fence, which is especially concerning since, as I mentioned before, the balls come over at a great velocity at times. My garden is just across the sidewalk next to the fence, which is approximately 12 feet away, and once a golf ball landed just outside the garden as I was standing there. Over time, we have amassed quite a collection, so we have even entertained the idea of collecting them all and becoming a supplier of balls to the club. That's supposed to be a joke. We are very much in favor of allowing the existing netting to be raised an additional 20 feet or so to correct this problem. In the summer, you can't even see the netting on the other side of the fence because of the trees. And in the winter, it's a bit more visible, but not obviously so. As a result, the additional height should not be a problem. We understand the county board is not in favor of this process, so we need your help in approving this solution because it is a safety issue. And it could involve legal action if someone gets injured. Therefore, please allow the Army-Navy Country Club to add the additional 20 feet or so to the existing fence between the driving range and our community. It will definitely give us peace of mind. Thank you.
Thank you.
Can I ask for a clarification? Did you say the county board is not in favor of this?
I understand I'm probably not saying the right words, but it was not approved. They tried to have it approved and it wasn't. I understand. I'm not.
I think she means staff.
Staff. Okay.
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 Thank
Any
you.
other questions?
That's good.
Thank you.
Okay. That's the last speaker. Do you have any comments, questions?
Motion?
Mr. Smith.
In a commercial district, if this was zoned commercial, what would be the height limit?
It depends on which district. You could have anywhere from 35 feet to 95 feet and above.
Okay.
Motion?
Yes.
Yes?
Yes, go ahead.
I move the Board of Zoning Appeals adopt the alternative resolution of approval for variance V-11045-15-VA1.
Is there a second?
I'll second.
It's been moved by Ms. Freshman, seconded by Mr. Melnick. Any discussion? All those.
Well, Mr. Chairman, in terms of discussion, I think the topography motivates some waiver from some relief from the strict application of the zoning ordinance. So I'd be in favor of the motion too.
Ms. Malice?
I will vote in favor of the motion. The thing that I was wondering about was some of the speakers and the applicant referred to the trees as being a part of what screens the fence, and those trees are on the applicant's property. I assume that the lower fence was his property line. So it's just, I'm not going to make this a condition or anything, but it seems like making sure that tree buffer remains there in the future is, I think, an expectation of the neighbors, that they won't be looking at a even taller fence without a tree buffer there. So I won't condition it, but I just note it.
Ready for a vote? All those in favor say aye. Aye. Opposed? Motion carries 5-0. Thank you.
Next case tonight is V-11053-15-UP-1. This is a use permit request by John and Coral Gunlock to permit a setback of 16 feet to the deck from the rear property line instead of 21 feet as required. This is in order to maintain an existing nonconforming rear deck in its current location. This is in the R6 zoning district, premises known as 2801 North Somerset Street.
Are there any questions for staff? Can we hear from the applicant, please?
Good evening.
Hello.
I think everything in the report is very well stated, so I wanted to actually thank the staff for their back and forth with me to make sure I had all of the required paperwork. So this is us just trying to make sure we get everything straight. We've invested in the deck. We've been enjoying it with our two young boys for years, and we just want to make sure we're in compliance.
You're John Gunlock.
I'm John Gunlock. I should have introduced myself. Apologies.
That's okay. We like to get it on the
Of
tape
course.
record.
Yes.
Okay. Any
Just
questions?
confirming that you built it without a permit, so what we're doing is really just legalizing it.
Yes,
Yeah.
we had done an addition on our house, and when the deck was put in, we were not aware of the setbacks. So.
Okay.
All right.
Mr. Chairman, quick question. Who did the did you personally do this construction?
No, we paid a contractor to do that.
Okay, the contractor wasn't aware of the.
Yes.
Didn't do their due diligence.
That is my position.
Okay.
We've since gotten quite smart about all the rules.
Is there a motion?
Yes. Go ahead.
Okay. All right. So in case V-11053-15-UP1, I make a motion that the Board of Zoning Appeals adopt the attached resolution approving of the subject use permit with the conditions as listed.
Motion's been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Thank you.
Thank you much, very much. Thank you.
Next case is V-11054-15-UP-1. This is a use permit request by Luann Wanders to permit a setback of 15.5 feet to the eave and 16.5 feet to the porch base from the 22nd Street South right-of-way instead of 21 feet as required. It's for the construction of a new front porch. It's in the R5 zoning district on a premises known as 829 22nd Street South.
Can we hear from the applicant, please?
Hi, I'm Luann Wonders. Thank you for your time. Thank you for the recommended approval. I have letters from my neighbors saying that they think it's a great idea if you'd like to have copies.
Thank you. Are they?
They're all stapled. There's 5 copies.
5 copies. Okay, great. you have anything to add? Do board members have any questions of the applicant or the staff?
My only question was about neighborhood outreach, which has been answered. So I'm prepared to make a motion.
Ms. Freshman.
I move the Board of Zoning Appeals adopt the attached resolution approving use permit V-11054-15-UP1, subject to the conditions listed in the resolution.
Second.
It's been moved by Ms. Freshman, seconded by Mr. Smith to approve the request as requested. All those in favor say aye.
Aye.
Motion carries. Thank you.
Okay, the next case is V-11055-15-UP-1. This is a use permit request by Catherine Campbell and Ben Hanks to permit a setback of 3.3 feet to the eave and 3.8 feet to the stoop base from the right side property line instead of 8 feet as required. So the construction of a new right side covered stoop with stairs. This is in the R6 zoning district, premises known as 2400 North Quintana Street, and the motion is to defer this case to the October 14th, 2015 BZA hearing.
Motion.
Ms. Freshman.
I move the Board of Zoning Appeals adopt a resolution to defer the use permit B-11055-15-UP1 to the October 14, 2015 BZA hearing.
It's been moved and seconded. All those in favor say aye. Aye. Motion carries.
Next case is V-11056-15-UP-1. This is a use permit request by Randall Hayes to permit a setback of 16.1 feet to the eave and 17.1 feet to the porch base from the North Quintana Street right-of-way instead of 21 feet as required. Also 4.5 feet to the eave and 5 feet to the porch base from the left side property line instead of 10 feet as required. Finally, an aggregate side yard of 13 feet instead of 18 feet is required. It's for the construction of a new wraparound front porch. This is in the R6 zoning district, premises known as 1305 North Quintana Street.
Any questions for the staff?
I have one.
Mr. Melnick?
This is just an administrative question, but on the disclosure statement, it looks like only lenders are mentioned. I just wanted to bring that up. I didn't know if that has any impact.
Sorry, what was that?
It's a disclosure statement that's
Yes.
notarized. And it looks like it just has lenders on it.
Let's see.
Instead of the Hayes. I just noticed it. I didn't know.
Which portion? I'm not seeing it.
Right here.
Oh.
See, when it says name.
Gotcha.
In case any correction had to be made.
Yes. I don't see that as an issue. As the owner has signed down below for applicant's signature.
Okay.
So you should be okay with that.
Any other questions? Can we hear from the applicant, please?
Yeah, just like to thank everybody for their time. Appreciate it. It's a dead-end street. We have 3 small children. There's 23 kids on the street. A lot of the social activity is all done in the street, in the front yard. So we just like to enjoy the front yard a little bit more, moving forward. So we just ask that you accept the zoning office recommendation for approval.
And you're Randall Hayes?
I am, yes, sorry.
All right. Any further questions or motion?
Mr. Chairman?
Mr. Smith?
I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit V-11056-15UP-1, subject to the conditions which are listed in the staff report.
Second.
It's been moved by Mr. Smith and seconded by Ms. Freshman. All those in favor say aye.
Aye.
Motion carries 5-0.
Thank you.
The next case is V-11057-15-UP-1. This is a use permit request by Christopher and Jeanne Hargett to permit a setback of 21.3 feet from the 2nd Street North right-of-way instead of 25 feet as required. And it's for the construction of a new pergola above an existing rear deck. This is in the R6 zoning district, premises known as 4610 2nd Street North.
Any questions for the staff? Hear from the applicant, please.
Thank you for your consideration. I'm Christopher Hargett, owner at this property. This property has no on it, as you can, and no mature trees on it, as you can see, and we are just wanting to put a pergola on an existing deck to allow for some shade during the summertime.
Any questions or comments? Motion?
I move the Board of Zoning Appeals adopt the attached resolution. Oh, sorry.
That's all right, I was just going to, you have two neighbors behind you.
I do, and I believe both of them have signed.
Sign? I was looking for
Packet.
4609, I noticed didn't sign.
102nd Street North, that is directly behind us.
Nobody had any, 4609?
Nobody had any problems.
Okay, I just checking. Thanks.
Good party will do.
I'm sorry?
It's amazing what a good party will do.
It's designed to get you out to meet your neighbors, right?
Like, a cookout solves a lot of problems.
Ms. Freshman?
Yes.
You want to make your motion?
I don't know. Okay. I move the Board of Zoning Appeals adopt the attached resolution approving use permit V-11057-15-UP1, subject to the conditions listed in the resolution.
Is there a second?
Second.
It's been moved by Ms. Freshman, seconded by Mr. Smith to approve the request. All those in favor say aye.
Aye.
Aye. Motion carries. Thank you.
Thank you.
The next case is V-11058-15-UP-1, use permit request by John and Dorte Hardage to permit a setback of 3 feet from the right side property line instead of 8 feet as required, and 8 feet from the 24th Road North right-of-way instead of 25 feet as required. So for the construction of a new detached carport in the rear yard. It's in the R6 zoning district, premises known as 4647 24th Street North.
Chairman and the board, I'm John Hardage. I regret my wife, Dorta, is not here tonight. It's past her bedtime, and it's approaching mine as well. I admire your stamina tonight.
Thank you.
I'm here because we didn't have a party, and we're trying to build a carport in our backyard. Our house fronts on 24th Street North, and the back of the lot fronts 24th Road North. And our idea is to put a carport in the backyard so that we can have access to it from 24th Road. The reason for this is we don't have any cover right now for our cars. We have a short driveway in the front that's really little more than a parking pad for two cars. My wife and I struggle with the winters, and when we go out and try to clean off the car, it's just getting to the point where it's quite difficult. I'm almost 60 years old. I had a bad fall last year. It wasn't a big deal, but it just makes you aware of the fact that it's a problem, and it'd be much better for us if we had a cover for the cars. So the idea is to put this in the back. I've taken some pictures, and I have them here for the board. If you'll indulge me, I'll bring them up to you. I have a picture of the backyard and the site, which is where we'd like to put this. I would note that I'm sure the staff can speak for itself, but the staff has noted that there's a problem with compatibility. I would actually take issue with that. The house immediately to our right has a brick two-car garage very close to our property line, and the house on the left has a brick one-car garage very close to our property line. And in terms of a precedent for access onto 24th Road, we have a neighbor 2 doors up who has So there's clearly not, at least in my mind, a compatibility issue. I would like to provide you just with a copy or a picture of our house with that includes the front driveway, which, as I said, and as part of our plan, the notion is to remove the asphalt driveway and restore it to green space, so we would add grass and some foliage to that space, giving the front yard more balance and more appeal. I know I cannot speak for the neighbors. I know there's some discontent about it. I don't know what the arguments are. I'll let them speak for themselves. I know that one of the issues that has been raised as a concern is a project initiated by the county related to Donaldson Run, a restoration of the stream project, which is not far from my property. I actually had a conversation today with Elizabeth Thurber, an engineer with the Department of Environmental Services, and she provided me an email, which I can provide for the record if you would like it, or I can read it into the record. But her note says that when I prepared all of the plans and sketches, I did not show any impact to your property. All improvements will remain within the county right-of-way. So to the extent there are any objections related to Donaldson Run, I don't think there are any, at least from the perspective of Arlington County. She also noted that 24th Road is slated for repaving and construction of a turnaround at the end. The road is extraordinarily narrow. It dead ends at the home of one of my neighbors. And so the idea, as I understand it, is to create a turnaround down there. So again, I don't think my project is going to have any adverse impact, but I'm happy to answer any questions you may have. I have also with me, I'm accompanied by the contractors who can help answer any technical questions.
Do we have any questions for the applicant at this point? I have a question for the staff before, you can sit down, Mr.
Okay.
We'll call you up. I want to ask the staff a question before we go any further. Just trying to look at the plat. Is there a position in the backyard, behind the house, where this structure would sit as a matter of right and access 24th Road?
It's possible. It's possible. I'd have to probably draw it in. They would have to be 8. Actually, this is a carport. They wouldn't have to be 8 feet from the home. So I would say yes, they could be. This is not a detached garage where you have to have the 8-foot setback from the home. You can be anywhere in the buildable area with this structure. So 8 or 10 from the sides, 25 from the street.
25 feet off of 24th Road property line.
Correct.
And 8 and 10, just to use round numbers.
Exactly.
Okay. So conceivably, there is a way to access 24th Road to a garage or a carport or whatever. And you said
In
garage
addition to the house, correct? Mm-hmm.
Okay, thank you. Let's move on to this. Anybody have any questions? Ms. Malice.
Just to follow up, so that includes the creation of a curb cut off of 24th Street to the back of this site?
That would, yes.
Okay. Well, let's wait.
Okay.
Let's wait. Let's hear from the speakers, and there might probably going to be a lot of other questions and so forth. Lynn, and I apologize if I pronounced the name wrong. Lynn Backy? Well, you can tell me when you come up here. I can hear you then. I'm sorry if I butchered your name. Welcome.
Hello.
And you can tell me your name for the record.
Lynn Bake.
Bake.
My father is the owner directly across from their property on 24th Road. He will be deeply and negatively affected by a curb cut and a garage a mere 8 feet from the road. It will impact them getting into and out of their driveway. It also is a danger because there's not good sight lines there. Our neighbor Bill Moore wrote a letter that's been put into record about the danger of turning wide to get out of there. The property was bought knowing that they had no garage there, no access from our street. Our street is very narrow. Already parking is an issue. access to parking and getting on and off the street is difficult. When people park there, sometimes emergency vehicles can't even get down the street. So losing 2 parking spots just from that and additional spots because people can't get by will negatively impact my 83-year-old father. So with all due respect, he's older than you. I think that more neighbors would object if they had more time to think about this. Already, as they are discovering this, they're not happy. So I would urge you to reject it. Without further study, I don't think it would be prudent to accept this.
Any questions?
Real quickly, Mr. Chairman. Oh,
Mr.
Ms. Malice
Smith.
first.
Ms. Malice?
What is the address of your father's property?
4625 24th Road North.
Okay, thank you.
Directly across.
And does he have a driveway?
He does, a carport.
On the same street?
They front onto 24th Street. Their backyard is directly across from ours.
But your father has a carport
Yes.
on 24th Street as well?
24th
Road North. That would be across from this proposed carport.
Back where their garage is proposed, they would both be backing out into each other if they try to get out.
Okay, thank you.
No, I had a question also.
Ms. Beck, I'm sorry.
How did you learn that this was being proposed?
They sent a letter to the house to my father, and eventually he showed it to us because he was concerned. He wanted to come here tonight. That property used to have a garage on it that fronted to 24th Street. It had a driveway going to it. I don't see why they can't still do that.
Okay, thank you.
Sandra Bake?
Hi,
Welcome.
I'm also speaking on behalf of my father. As my sister mentioned, he wanted to come tonight, but he's in his 80s, and this is a very long meeting. If the garage is built as proposed, it's a very narrow street. In order to access that garage, you would have to swing wide to get into it. And that would mean that they would come into the oncoming traffic lane in order to get into the garage and possibly even onto my father's driveway. To me, that's a safety issue. It's a short and narrow dead-end street that already lacks sufficient parking, and it can be difficult to navigate, especially on weekends when everybody's at home and everyone has guests or workmen coming over. My father wanted me to let the board know of an incident that happened last year where he fell in his house, and the ambulance came to get him, but it could not make it down the street because the cars were parked too close together. Now, usually just a single car could go by, but the ambulance couldn't. They had to wheel him up the street to access the ambulance. So to my father, this is a safety issue. Losing further parking spaces on 24th Road will only aggravate the parking situation. On top of that, if this is granted, and that would include this parking situation became aggravated because of the variance that was granted to the residents of 4655 on 24th Street, where they built a garage attached to their house and then accessed their house from 24th Road.
Excuse me, Mr. Chairman, was that, you said 4655? They have a garage on the back?
I believe that's the house with the garage in the back. And now they access their house from our street. That meant that all those 2 or 3 parking spaces are gone, and so everybody else, as a result, clusters further together. Oh, am I out of time?
Finish up.
Okay. Other than that, if you allow this to happen, then the neighbor in between those 2 houses could also want to access their house from our street, and then we'd lose parking along that entire side of the street. And that would be an unfair burden to the residents on 24th Road. Thank you.
Ms.
Just-
Miles has a
just
question.
You mentioned the swinging wide to get into the driveway. Does your father have to swing wide to get into his driveway?
He swings kind of wide, but he has sort of a nice turn there, so he goes directly in. But it's hard to get in and out already of that parking situation. I wish I had a picture for you. We tried to.
We have a plat. We have a plat here that we can.
Here that show the street.
I'm sorry?
I think we have a few photos here that show that street.
Now they have a very wide street with plenty of parking. He also has a 2-car driveway. I don't really understand the purpose of accessing a driveway from our street. I mean, if he wants to build a garage and access it from the other street, we have absolutely no problem with that. It's just accessing his property from our street when we already have a very tight parking situation and it's already hazardous.
I have a question.
Mr. Melvin.
I have a question. Just a quick question for you. So what I'm hearing is your complaints are just about the parking and the near street and the crowding. Do you have any complaints about the appearance of it? How it appears from the street?
Our block looked like an alleyway, so which we also are not crazy about. I mean, not me, my father, and the other residents on 24th Road certainly aren't crazy about that. I think it's unfair to put that burden on the residents of 24th Road in order just to keep a car covered.
Okay.
Thank you.
Why McLear? I apologize about that. Please state your name for the record.
Yesham McAleer, and I live right next to Lou Bake. I'm on the right-hand side, 4707 North 24th Road. The residence with the garage facing me is right across the street that they had just spoken about. That already causes problems for us. So in other words, their garage, their driveway that they used to get in their garage is right across from our driveway. We have to move our trash cans during trash day. We cannot park our car where we want, so that they, out of courtesy to them, we move it back. We can't put 2 cars out there out of courtesy for them, so that it already causes problems. But basically, it's really about the safety issue. We've been there for 15 years. There's 4 of us in the family. All 4 of us have had accidents backing up out of the driveway. And 1 car was coming from the street on the other side. You can't really go 2 cars at the same time at a certain place. And they were on the other side, and my son was backing up, and they hit him, or my son hit him. My husband, one of the neighbors, their guest was backing up. My husband hit him, and this just goes on and on. I was a witness to the ambulance not being able to get by when Mr. Bake was there, because we were about to leave, my son and I. We couldn't leave because the ambulance couldn't leave. And we tried to make sure that Mr. Bake was okay, but finally they just reeled him out of there. Okay. The other thing is they're neighbors with children, 4 and 2, 4 children and 2, and kids are kids. Even though if you say keep them on the on the lawn, they'll dash out. We just don't have the space for all this traffic, so that's going to be another 2 cars coming in, another 2 cars going out. And we have a carport. We can't really fit our car. We just park outside, so we don't have anything that's covered either. I've spoken to Mr. Haggerty, and I really respect him, but I've tried to see if it could work in any way, and I just don't think it can.
Okay, thank you very much.
Sure.
Adam Clotter.
Good evening. My name is Adam Clotter. I live at 4717 24th Road, so I live a little farther up the road toward Old Dominion. Thank you very much for your time. I think it's important to hear from the neighborhood here on this. My wife, Christine, and she wasn't able to come, but we oppose this for 3 reasons. The first is safety. We're one of the families with children on the street. We have 4 young kids, ages 8, 7, 4, and 3. Our front yard is one of their favorite places to play, and we We try to keep them out of the street to the extent we can, but occasionally they do drift into the street, and we are concerned with any increase in traffic on our street. For a small dead-end street, we seem to have an inordinate amount of traffic coming up and down the street. So, as is mentioned, a two-car garage, and the applicant does have teenage children. So I imagine a significant increase in traffic for the size of our street. We also oppose it on the aesthetics. The width of our street has been discussed here by other speakers, but I also think it's an eyesore. I think from the plans that I've seen and the proximity to the actual street, I think the detached carport it just is not in keeping with the neighborhood. And I think the staff's report on how this structure differs from other structures in the neighborhood is covered in great detail. I mean, some of them were built prior to 1950 when our street didn't even exist. Some of them actually have the proper setback and are attached to a home. So I think that's covered quite well there. And my last point of opposition is just a common sense argument. 24th Road is a street. It's not an alley. And I just have a fundamental opposition to attempts by this applicant to use our street as his alley. He has a street. He lives on 24th Street. As he said, he has a driveway, a two-car driveway, and I just think it's just unfair for him to use our street for his parking and his ingress and egress. Thank you for your time.
A.S. Campbell, please.
My name is Jay Campbell. I am 4711 24th Road, so I'm in between the last two speakers. I'm the house with the two children who play with the four children next door. And it's getting late in the evening and your time is extremely valuable, so I don't want to repeat anything that was said, but do want to say that I agree with everything that was said by my neighbors. I would add that a detached carport is not something that is in the neighborhood. There are a handful of attached carports that are integrated fundamentally into the homes, but there are no detached carports. As you've heard now from the three residents who lead up to this carport, we are really concerned about the increase in traffic because we see it already, how much traffic there is going to and from Old Dominion on 24th Road. 2 cars more coming in and out a couple times a day. It just doesn't seem sustainable. Thank you.
Thank you. That was the last speaker. Does members of the board have any questions or comments? Ms. Malice?
I wanted to follow up on the point that you made earlier about the by right option. It would really be helpful to see what that would look like. In other words, even though the neighbors may object to this proposal, there is an option that the applicant has that could be done by right without any permission from the county.
That's correct. That's correct, other than a building permit, of course.
But would require.
Yes, environmental services would have to approve a curb cut as well.
And they would do that based on what criteria, do you know?
It's mostly in subdivision code.
Okay.
Yeah, and if you do all the engineering that is prescribed in the subdivision code, nobody can stop you from doing that. The subdivision code is administrative under the state law, and neither the county nor the can divide that. I'd like to make the point right now, too, that we're being asked for a carport that requires variances for the structure or use permit modifications of the requirements for the structure. Just like the house down the street that has the garage on the back of it, obviously that got approval of a building permit, meets whatever requirements, and can access 24th Road. This applicant could do something that met those requirements as a matter of right and access 24th Road, and my guess would be that you could also build a curb cut and have a driveway and park cars off of 24th Road without a structure in the setback. So that's what makes the issue of traffic on the street really difficult for me. I really understand narrow street and the character of the street and all of that in terms of whether we approve a carport or not. But as I understand it, lots fronting on a street have a right to access the street. In this case, this happens to be a lot that has frontage on 2 streets, which for some people is good, as for some people is bad. But that's something I think that's clouded in this question.
So just to clarify, so it's the structure itself that's in question. It's not whether you can have a driveway or park your cars there or have a curb cut there.
Exactly.
It's a question of this particular structure or any structure.
Setbacks for the structure, exactly. Yep.
I just, at some point, I'd be interested to see what options the applicant explored in that.
We can ask him, why don't you go ahead with
And Mr. Chairman, nothing prevents the applicant from parking back there on the street right now and either hopping over his fence or cutting a hole in the fence and walking through and accessing his home and parking on 24th Road right now, and we're parking 2 cars back there, even on the road. And then going through his backyard home. Nothing prevents him from doing that right now.
Sorry. It's with the board now. Excuse me. If the board has a question for you, we'll bring you up. As I mentioned at the beginning, there's no cross-examination or responding unless asked by the board. I appreciate it. I understand being upset over it, but those are their procedures that I mentioned at the beginning. Mr. Melnick.
Yeah, I'd like to ask the applicant another question. Concerning, so a lot of the comments have been about parking and traffic. A few of them have been about aesthetics, and that this is something different, a detached carport out in the yard as opposed to attached to a home. You've also heard about, what you can do by right. So what, have you explored by right options? So, you wouldn't have to, go through a use permit
No,
process?
sir, I have not explored that for the main reason that it would be a good deal more expensive to try to attach it to the house. This was our preferred route because it was simple, it was elegant, it was a carport, not a monolithic big garage. It was airy, it was meant to blend in, it was architecturally refined, and it was accessible from 24th Road in a what we thought was pleasing, aesthetically pleasing way, with all due respect to the previous speakers, for whom I have respect for whatever concerns they may have. But so no, we have not explored other options because of the prohibitive cost.
Thanks.
Thank you.
May I follow up?
Ms. Miles has a question for you.
You didn't explore a garage. Is that what I understood you say?
We did not explore a structure attached to the house.
Did you explore other locations for your carport that you could do by right?
Choices are limited, as I understand it, and I'm certainly no expert. I defer to staff and their comment on where it could go. But if it goes right smack in the middle of the backyard, it's very inefficient and limits the use of the rest of the space of the backyard, hence the idea of moving it to one side of the backyard. Now, we could move it to the other side of the backyard, but there's a large tree there, and I'd hate to see the tree affected in a bad way, or if it would have to come down and be trimmed back severely. So the idea was to put it on the side with no tree and try to make it as pleasing as possible aesthetically.
Thank you.
Any comments or questions from anybody else on the board? Is anybody interested in making a motion?
Oh, Mr. Chairman, one last question.
Mr. Smith.
I'm sorry. Our report says staff hasn't received any signatures from neighbors in support of or opposition to the proposal. Can the applicant describe whom he contacted personally and or what was their reaction?
Yes, sir, and I will confess that I'm new to this process and was completely unaware of the passion that it was going to engender, and so that I chalk up to my own naivete, but that's the way it was. And so I did not approach the neighbors until this past weekend, when in sort of I was working in my backyard, and one of the previous speakers had driven up to her dad's house. Her dad is in an assisted living facility now, so she drove up to the dad's house and was unloading material or something, and I just hollered across the back fence, and I said, I just want to make sure you understand this is what we've applied to do, and this and that. She told me at that point that she was firmly against it, and which caused me to immediately go to all the other neighbors and ask them if they were concerned, if they had concerns, and if so, could I describe it in a way or help them understand what we're trying to do, and to try to be sensitive to whatever concerns they had so that I could address them. And that's when I discovered that some neighbors were, as you heard already, adamantly opposed to it for various reasons, and others were more or less agnostic. My neighbor right directly next to me who rents the house, they have no stake in it, but they don't care. I've told others who have just responded with no comment one way or another. So the answer is, yes, sir, I did it. I did it late in the process because I wasn't aware of how important it was for me to do it. So I regret that I wasn't able to do more. And if I may make one other final comment, just with respect to parking, thank you for your comments earlier. This is a picture of the backyard. Nobody parks there now. I mean, there are no cars. Parking is a red herring. I'm happy to share it with you. This is our property line over here, and Mr. Bake's property is here with the brick wall. If I can answer any more questions, I'd be happy to.
Mr. Chairman?
Ms. Malice.
All right. I'm sort of going through my options here.
Okay.
Obviously, one is to support the staff recommendation to deny, and if you then choose to build something by right, then your neighbors will have to accept whatever it is you build by right. The other option that I see would be to defer this matter for you to consult with your neighbors to work out designs and aesthetics in a location that might be more suitable or acceptable to them. I'm not asking you necessarily for a response, but those are sort of the options here. I don't know what my colleagues feel on this issue at this time, whether what their inclination is, but those are two options that I see right now.
Any other comments?
Yeah, I'd support that comment. Just because there is such opposition, and the staff, it seems to me the staff's main problem is just how close it is compared to what they've seen around. So I'd recommend you go back and just see if there's some middle ground, something else you can do. That's what I would say.
Okay.
Let me just add, and I spoke to this a few minutes ago. What concerns me the most is that there was a lot of discussion about traffic on the street and parking, and as I see it, and my colleagues and the administrative staff can correct me if I'm wrong, folks who have frontage on this street have a right to access the street. And there's nothing we can do to deny that. Like I said, if we don't approve this, and he wanted to put a couple of parking spaces off of 24th Road back there, he could do that probably with very little in the way of even a permit, and it's actually a right. So, when we have these meetings here, I often hear folks bring up issues that are either out of air control or a matter of right to property owners, and there's not anything we could do about it. So, I wanted people to understand, since we have almost everybody who lives on 24th Road with us, that if we deny this and he puts in parking spaces as a matter of right, there's not a thing anybody can do about it. Just like the garage further up the street, accessing from that same side. So that's been my concern in this case. I certainly would support deferral for people to work out a solution.
So I guess part of, we would not move forward with the deferral without knowing whether you were inclined to work with your neighbors on this, or whether you would just prefer to move on,
I'm open to working with anyone, but I will say that the level of passion related to this discourages me in terms of finding some middle ground. I would be happy to try. If perhaps staff would be involved as a mediator or something in between, that might work, but
I don't think staff takes that role, but I think the piece of information that I think our chairman is trying to convey to your neighbors is that you have rights, to build a driveway in the back of your house, and even to put that carport in the back of your house where staff tells you that it's permitted. The reason that you're here before us is that you've encroached on one side, you've gone too close to one side. But your neighbors need to understand that you do have the right to build something back there. And the question is, maybe put it the other way, would they like to have input into your decision?
Right.
So it's sort of really a two-way street here.
Right. Great analogy. Okay.
Let me make a point. We could do several things. One, you could just go, I want a decision from the BZA right now. Or we could defer it if you thought there was some possibility there, and you decide not, you can withdraw the case before the deferral comes back, for that matter. Or you can come back at deferral time and we can see whatever it is that's been worked out, or we can have this meeting all over again. So it's sort of all with the applicant if we defer it. If we take an action tonight, that's the end of it for this proposal, one way or the other.
Okay. Well, then I think deferral makes sense as a path to try to figure out some alternative.
Okay, it's with the board. I will entertain a motion from somebody.
The thing that I failed to ask the applicant in terms of the deferral was, do you have a particular timeline that you're working on? Do you have constraints?
Well, yes, ma'am. Optimally, I'd like to do this the sooner the better, because as I referred earlier to the project that's going to occur on 24th Road related to the stream control, the old Donaldson Run stream control project, which I understand from the engineer with whom I spoke today that it will occur probably in the early part of next year. I'd prefer to have this done and out of her way, part of my timing crunch, but...
when we make a deferral motion, we usually make a motion to a particular month, and I'm wondering if 1 month is sufficient for you to meet with your neighbors and come up with a revised design. Usually we would suggest a 2-month deferral. So that would be to the November meeting.
Which is November 18th.
November 18th. So you think a 1-month deferral? I mean, this is... But it has to get to staff. Does a 1-month deferral seem reasonable to you?
It's October 14th.
They would have to get in at least a plat to me with a footprint with setbacks by this coming Monday in order to publicly advertise it.
Yeah, that's why 1 month is difficult, because of the internal staff. I mean, we can make a deferral to 1 month if you can make it. I guess the alternative would be then you just ask for another deferral yourself. But that's what you're up against, is basically you've got the rest of this week.
On the 25-foot setback, if we go 25 foot up with the carport on his patio, and the other one you were looking at was an 18-foot setback, which puts it touching his patio.
Work with the staff.
We can't address that.
We don't address this, the staff does.
It's too much. So a 1-month deferral, and then you can extend if you need to. Thank you.
Thank you.
I move that the Board of Zoning Appeals defer use permit V-11058-15-UP-1 until the October 14th meeting.
There's a second. Moved by Ms. Malice, seconded by Ms. Freshman. All those in favor say aye.
Aye.
Aye. Motion carries. Thank you all.
Okay, the next case tonight is V-11059-15-VA-1. This is a variance request by Pamela Harris to permit the construction of a new 2-story detached single-family home on a lot that does not meet the width and area requirements of the R27 zoning district. It's an R27 zoning district, premises known as 1933 South Lorton Street.
Do you have any questions for staff? Okay, look, could we hear from the applicant on the variance request, please?
Good evening. My name is Pam Harris-Strawn, and I would like to thank this opportunity to address the board. I am here with the architect who is going to follow me and present the plans to build a home on the property. I've been a resident in Arlington all of my life, and for 57 years. The property's been handed down to me from grandparents to parents, and now I am the owner of it. And all of this time, it's been a vacant lot. And so, as a resident of Arlington, I've seen the revitalization in South Arlington. And so what she has put together is a really nice plan that really sort of falls into the plans that we've seen in the revitalization in Arlington to really bring a new home to the street that has some real nice character and charm to it, that fits the style of the neighborhood, where it's not too oversized or overpowering the other houses that are on the street. So tonight I would just like to ask the board for your approval for the variance to be able to move forward. But I cannot speak to the details of the property. The plans, I would have to defer that to the architect who's here.
Okay. Welcome. This is the variance.
Here to answer any questions that you might have.
Well, that's good. Let's see if we can't do this together. So we're working on the variance right at this moment. Let's wait for questions for you, but let's hear from, we do have one speaker who perhaps has listed the variance as what she would like to speak to. Could we hear from Lindsay Arthurs, please? Or he would like to speak to. He's against it. Okay. Sir.
Good evening. Lindsay's my wife. She had to go home. We have a 9-month-old, so it's bedtime for her. So I'm John Arthurs. We live on the adjacent property to the left, which is 1927. Thank you for allowing me to speak. I wanted to weigh in on the proposed development of the vacant lot next to our house. When we purchased our house in May, we knew that there would be a house there sooner or later. So a house being built isn't our issue at all. I'm here today to voice my disapproval of the variance, changes of the proposed building design, as it will have a daily impact on our lives. Until we received a letter last week from your office, we were unaware of any specific plans and were never consulted. I'd first like to point out that the applicant will not occupy the house. This is a house strictly being built for sale. Staff analysis stated that granting the variance will not be a detriment to the adjacent property in proximity to the geographic area. I don't see how our lot would not be impacted on a daily basis, nor do I understand how those conclusions can be drawn without contacting us when we're talking about moving something much closer to our property line. Also in the packet, the signature pages of approval seem very vague to me. One page says I approve, and the other says I don't disapprove. One signature came from someone in Alexandria, so I don't know how that even factors in. And if you notice that neither of the adjacent neighbors have signed either of those documents. As the plot attached to the variance application shows, the variance request is for 6 feet to the left side, which is inside the 8-foot setback requirement. From the plat, you can see my driveway, which is also the property line, where we have a side entrance currently. And as you see from that dumpster, we're undergoing a huge renovation project where that entrance is actually going to become our front entrance way, and it goes into our kitchen. I'm running out of time, so I guess my main conclusion is, in looking at it, I'd like the idea of maybe flipping the house the way it's designed now to the other side where they don't use that as a front entrance. Also, on the proposed plat, there's 2 AC units that are going to be right in front of our front door, which isn't going to be very aesthetically pleasing at all. So if anything, at the very least, I'd like for those to either be moved to the back of the house or somewhere where I'm not walking out with a 9-month-old to a noisy air-conditioned unit every day.
Okay, let me ask you some questions.
Okay.
First of all, you're speaking to the use permit, which is the next item, but I don't know why we can't just, when that item is actually called, we'll just say, do you want to say anything else? Because you understand that the variance is a request to permit construction on the lot. So I think you stated that when you moved in, you knew that there would be a house constructed there.
Yes.
Yeah, okay. So
I mean, it was a vacant lot, but we figured it's Arlington.
Looked like
a
a
house
house
is
would
going to
go there.
go up at some point.
Look, it's actually, you might even call it a technicality in the ordinance as to why a variance is necessary to put a single-family house on the lot. That's why we have two things. But you're speaking to the design of the house and I'll use the term variance, which isn't really correct, to the required side yards and setbacks and so forth.
Correct.
Yeah, okay. That helps me understand.
Okay, sorry, I didn't know there was a difference.
You didn't do anything wrong. Thank you very much. So, Mr. Smith has a
quick
question.
Your lot is approximately the same size as this lot?
I would guess so, yeah.
A little bit larger.
And I mean, generally, the placement of your structure is like this one. I mean, these are all small lots.
Yes.
So your idea would be to flip it to so that the entrance is on the other side, away from yours, and that basically put mirror it.
Their entrance is going to be in the front, which is fine. Our entrance will actually be, like if you're looking at our house, kind of where that dumpster is in the picture, our front door is to the left on the side of the house. So if you were looking for, so that's the other neighbor, and there's no entranceway on that side at all. So I was thinking the variance could go to that side if need be. Just beyond that.
We have in the staff report, if I may, we have in the staff report a better picture of your house. Your entrance is going to be where the little bay window is? Is that what you're telling me?
Come up.
Sure.
Yeah, so actually, this right here
is going to be
is
your
a door.
It's going to be your front door.
Yes.
Okay.
So your door is going to be on the side of your house?
Yes.
Yeah. He said this door is going to be.
So as opposed to your steps go up the front right now, you're redoing your whole house.
Yes, well, not to get into it.
Are you going up with it?
No, so in our basement right now is a large family room and a kitchen, and so we just are remodeling that and then make that our main entrance way.
I got you. But the front is going to stay the same? With the stairs going up to your front door?
On the road, we're going to knock out the stairs. We've made... Yes. What?
This construction's going on right now. The front is going to stay the same with the stairs going up to a front door. You're just putting a door on the side, an entrance on the side right now.
Well, there's already an entrance. We're just doing the renovations to make that our main entrance.
Okay, but you're not taking out the entrance that's already on the front of the house?
It will be. Right now, no.
Okay.
But we've converted, that front door opens into a bedroom now, not like a living room or an entranceway.
Okay, thank you, John. Appreciate it. So those are the speakers. Do we have any questions for the architect who
I
made
do,
herself
Mr.
available?
I do, Mr. Chairman.
Mr. Smith?
Obviously, one of the big questions is the movement of the AC units to the other side of the house.
Right,
Or to the rear of the house.
right,
That's possible, isn't it?
Absolutely, and I spoke with his wife, who was in here earlier, and I told her I have no problems moving the AC units over to the other side of the home, if it was okay with you guys. And I promised her I'd talk to you about doing that as well. And I also did go by the home to show them the drawings of the house and the proposed home and all of this, but there was no one home except the contractors were there. They were working on the property with the dumpster there, but at that time that we were doing the street survey, which we were there on 2 occasions, there was, they had not moved in yet, so. And I would also like to talk about, he mentioned that he would like us to flip the house footprint around. And the reason that would be a hardship would be because the driveway is, or the Arlington County right-of-way is over to one side. Now, the way it's arranged now, he's saying that he's entering his house on the side. And the way it is now, our entryway would be not visible from his.
Right.
It's recessed.
So I would think that would be more desirable than having 2 people entering, together. That's just a thought, but I thought the air conditioning units could fit right in between the almost exactly opposite to where they are now, and I have marked them on the plat. If we were to move them over to the other side of the house.
Can we have this?
Yes.
Here, you guys look at that. Just while we're on this topic, I call the board's attention to the plan view north elevation, which is the side that faces Mr. Arthur's. Doesn't show the air conditioning units, but we know where they would be on his side.
Yeah. Well, that's something to consider when we get to the use permit. Any other questions right now? Maybe we could dispatch with the variance? There's a discussion among the board.
On the use permit, I want to ask Mr. Noxon about this odd configuration of the street with that little notch.
Something stupid the county did.
Do you want to move the variance?
If you are recommending
Moving it. I would like to make a motion that the Board of Zoning Appeals adopt the attached resolution granting the variance V-11059-15-VA-1, subject to the conditions listed in the resolution.
Second.
It's been moved by Ms. Mallison, seconded by Mr. Smith to approve the variance as requested. All those in favor say aye.
Aye.
Aye. The motion approving the variance is granted. Now we're with the use permit. I'm going to just quickly, just for procedure, call Ms. Hairstrawn. Did you have anything else to add? Okay. Mr. Arthurs, do you have anything else to add? I'm sorry, you went over there. Come up to
You
the
you need to
microphone.
speak into the
He
mic.
likes to sit at the back of the class. So did I.
Did you really?
I think use-wise, I might have misspoke. When I said flip the house, I didn't mean the configuration other than moving the AC units.
Okay.
But I was wondering, since that's our main entranceway, why could we do the variance on the other side, like the 2 feet that they need? That way we wouldn't be walking down like an alleyway in order to get into our house.
Well, we'll take that under consideration. Thank you for that additional testimony.
I'll call the use permit case. This is V-11059-15-UP-1. This is a use permit request by Pamela Harris to permit a setback of 8.5 feet to the stormwater planter, 11 feet to the eave, and 12 feet to the wall from the South Lorton Street right-of-way instead of 25 feet as required, 4.5 feet to the stormwater planter, 5 feet to the eave, and 6 feet to the wall from the left side property line instead of 8 feet as required, 13.4 feet to the egress window well, 14.5 feet to the eave, and 15.5 feet to the wall from the rear property line instead of 25 feet as required. Finally, an aggregate side yard of 14.5 feet instead of 18 feet is required. So the construction of a new 2.5-story detached single-family home with a front porch, front left side stormwater planters, and a rear egress window well. It's in the R27 zoning district, premises known as 1933 South Lorton Street.
Thank you. So I've already heard I've already called the speakers because I want to go home. No, we're not going to give any case short shrift. So any questions of the staff or the applicant on the use permit?
I would like to just ask the architect, if you, based on the recommendations of the staff, which is denying some of the setbacks, what does that do to your project?
Well, that would really hamper the project. I've been reading over the report here, and I can't find in it where they state reducing any of the setbacks.
They're denying all the first ones.
Are you looking at the,
If you look at the recommendation on the
Page.
first page, it's
First
right in the middle of
page.
the first page.
Says what they're denying and then what they're recommending for approval.
needs the other report. You need
The
the
use
use
permit
permit
report.
report.
There's a use permit report over there as well.
It's got UP as opposed to the,
And I know everybody here probably won't be back here again, but the reports are available on Friday before our Wednesday meetings, online and through hard copy coming into the office, so.
Well, in the interest of time, you were recommending
essentially 3 feet less.
on the front yard setback. Well, that would greatly impact the home. And to illustrate that, I brought a sketch because the room at the front of the home is one of the predominant rooms, the dining room, which is
Thanks, Mr. Arthur.
Yeah.
This shows a table.
I see.
Is showing a dining room table with 2 chairs on the side and 2 at either end. And it's a very tight fit, even just to have that in there when you're supposed to have 3 feet behind the chairs. I don't even have that right now. If I move that setback back 3 feet, the room is destroyed. It's not even a room anymore.
I mean, it's only, Mr. Chairman, it's only 11 and a half feet deep as it stands. And other than that room, really the house is 24 feet by 28 feet. It's a really small footprint. And these rooms are really small. The master bedroom is 11 by 15, 12 by 16 roughly.
And also, in addition to, one of the neighboring homes has a front yard setback of 4.5 feet, which is on the, can be seen on,
Probably got a grid in here somewhere.
If I can ask a question of the staff. Drew, do you have a number for the setback from what should be the curb in front of this house instead of that funny parking space area?
I can certainly give you that in just a moment here. Here's what. Oops, it's 25. Sorry, I don't have the right scale for this.
20, between
Need to
25
do,
the depth of the
check it.
inset driveway there, that's 20 feet.
I think it's a little more than that.
Yeah, it looks more than 20. It looks more
She
than
must
20.
be only going to the sidewalk, because to the curb, it's got to be.
Yeah, that may be.
It looks like 30 feet.
It's close to 30. It's
Yeah.
between
You're right,
25 and 30.
it's close to 30 feet, because I have,
Those paved spaces are 30 feet deep?
Yeah, I'm getting 30 feet.
And then what we're talking about behind that, to the front of the house, forget the.
Mhm.
Right.
The bay window is another 12.
That's 25 feet there. Can they park in there? Can they park in there?
Okay, thank you. I'm trying to get a sense of the, effective setback. I also see that this is like chained off.
Yeah, that's the craziest thing in the world.
Right, those chains were set up by the, one of the neighboring, sort of creating their private parking spot. It's kind of temporary, you can see that.
Have you pursued having this vacated by the county?
Well, no, the Department of Transportation, they're aware of that, and they know that what these proceedings are about, and how once we put in a curb cut, we'll put up signs there. So
That's not my question. My question was vacating this so that it is not, so the curb is moved and grass is put in and there's not any spaces there.
Oh, they said no, that cannot be done. Well, they said it could be done, but it would be more like moving heaven and earth, because it would have to be approved by the
Board? Happens all the time.
County board,
you'd have to go,
environmental services, all of the above.
yeah, the
DES
county
is going
board.
to tell you, no, you can't do it the first thing you ask them, so.
I think they're reluctant to also because there's not a turnaround on this street. It just goes straight into a driveway for the townhomes across the street. So that's probably one of the reasons it's kind of a half hammerhead. It's a turnaround.
Right, that's the explanation of why that came into existence. It was initially created as to provide a place for cars to turn around, but that's no longer necessary, since at the end of the street they already have a turnaround. So this is just kind of remaining, a leftover.
I didn't mean to open a can of worms.
That was my concern. When I saw that, that's a.
Appearance of your neighborhood.
That's kind of our hardship here, is the.
In terms of the front yard, yeah, that's exactly.
Well, their line would still be behind the thing if it wasn't vacated. His line, Mr. Arthur's line, is not all the way up to the street either. There's an outlot in front of him. Do you own the outlot?
No, but I just add, I talked to the county specifically about the.
You have to speak in the microphone.
We have to get everything on the microphone.
I talked to the county about that, and if you look at my property line, it actually cuts off diagonally.
Yeah.
And they said as long as both owners agree for it back, they don't see any reason why the county wouldn't give it back because it's no longer used as an emergency turnaround. They made it seem like it wouldn't be hard at all.
Talk to the wrong people, yeah.
Yeah, it'll be hard.
What you do with these things is you pursue them very formally, and you get a different answer, in my opinion.
Probably beat a dead horse by talking about that little turnaround as well, just to give it some history, because I've been aware of it like all my life at 57. When the townhouses were built, yes, those residents would start to use that as a parking lot. And it really wasn't, it was unfair because it became an eyesore to the property. When the townhomes do have a very large parking lot at the end of the street, I've even driven down the street and been able to turn around there myself. So I think for the residents of the street, as you can see, prior to the residents moving in or anything, there were boats parked there. There were constant cars parked there all the time. So yes, and we asked them to move it because it did create such an eyesore to the street. So we're hoping that something can be worked. So that really brings a really nice, a beautiful home to the neighborhood that gives it that balance and look for the street. That's what we're trying to do.
Okay. Thank you very much. Any more questions, comments?
Question on the side setback. The adjacent owner had mentioned shifting the house further away from his property. Can you talk to that a minute? In other words, one side of the setbacks are not equal.
Well, I mean, it could be moved over, I would say, a foot without the porch encroaching onto the driveway. And certainly we could do that if the board would recommend that.
Is that worth it to you?
The problem with moving that over a foot is we'd have to advertise setbacks on the right side. So we get caught up with that. There may be the option to redesign the stairway so they don't need that bump out. I mean, that's one possibility. I'm not sure how that would work with the architecture of the floor layout and all that.
Yeah, you can cut feet off, but you can't move feet over.
Yeah, you're right.
Very tight.
Right, but we are moving the air conditioning.
Right.
No, you didn't move that.
Those can be moved to a by right position. Pretty much on any side of the house, you can still get those by right.
Okay.
And in fact, by moving the air conditioning, they're going to be further from the side lot line than they are proposed right now.
Right, yes.
And I'm sympathetic to Mr. Arthur's issue, but a foot, or even 2 feet is not very much. I wonder if you'd notice it.
I feel if you're talking only 6 feet as is, a foot is kind of a big deal.
Oh, that's a good point. That's a good point.
What is his side yard right now? Is it?
I didn't see any plats on file, so I wasn't able to find that out.
Probably from the edge of our house to the property line is probably 5 feet. I wonder if I'm understanding that we were grandfathered into a variance, before it was filed.
Your house? Didn't look like an 83 house, but that's, maybe. Maybe it had a variance in 83
I bet Miss Harris knows.
for an addition.
When that house was built?
Mr. Arthur's.
That looks older.
Again, this is older. relationship to the property line, I mean, I think we would be further away than
Well, those lines must have moved from that one to what's here.
Okay.
You're looking at an older plat that's included in the record that is, let's see here.
Does anybody else have any more questions or comments? Mr. Smith? Ms. Freshman?
I would like to make a motion. I move the Board of Zoning Appeals adopt the alternative resolution, approval as advertised, for use permit V-11059-15-UP1, subject to the conditions listed in the resolution.
Mr. Chairman, I'll second that motion with one condition alteration, and that's that the AC units be moved to the other side of the
Okay.
proposed new home.
Ms. Freshman accepted that. It's been moved by Ms. Freshman, seconded by Mr. Smith to approve the alternative resolution.
Does that include the front yard?
Yes, you can read the alternative resolution in here. It's your request.
As advertised, which means what you asked for.
Okay, thank you.
All those in favor say aye.
Aye.
Aye. Opposed? With it, the only difference is it includes the air conditioning units being put on the right side of the house.
Thank you very much. Good night. I hope you can go
Thank you,
home.
everyone. Thank you, Mr. Arthurs.
All right. This is V-11060-15-UP-1. This is a use permit request by Chad Mankey and Justin Jakolski to permit a setback of 5.6 feet to the eave and 5.8 feet to the columns from the right side property line instead of 10 feet as required, and 20.1 feet to the portico from the North Patrick Henry Drive right-of-way instead of 21 feet as required. Also an aggregate side yard of 10.7 feet instead of 18 feet as required. For the construction of a new carport on the right side of the home and a new front portico. It's in the R6 zoning district, premises known as 913 North Patrick Henry Drive.
Any questions of the staff? Could we hear from the applicant, please?
Hi, I'm Justin Jakolski. I read through the report and I'm pleased to see the recommendation for approval from the staff. And just want to thank you for your consideration.
Any questions for the applicant? Ms. Mellis?
The applicant, I'm trying to, I note that there were, you had neighbors that supported your application.
Yes, they're on the, so that's a very recent picture. See those boxwoods next to my car? Their driveway and their house is on the right.
I was looking for the documentation. I see one letter in here, but it's a little confusing. From 909?
Yes, they're my direct next door neighbor.
Where's the other one from? It said that there were two, and I'm just trying to...
No, I only specifically tracked down the owner of the one.
Oh, two signatures from one...
From the same owner.
Okay, thank you. Okay,
And
thank you.
that's the neighbor next to the carport.
Yes.
Got it. Thank you.
I don't have any speaker slips. Does anybody have any questions or comments?
Mr. Chairman?
Mr. Smith?
I move that the Board of Zoning Appeals adopt the attached resolution approving use permit V-11060-15-UP1, subject to the conditions listed in the staff report.
Second.
It's been moved by Mr. Smith and seconded by Ms. Freshman to approve the request.
Can I point out an issue with the condition? I just want to make sure that we state in the record that this is, condition number 4, there's a typo. It says 2015 for the building permit, should be 2016.
Oh. So noted.
Otherwise, their use permit expires tonight. In a little over an hour.
Okay,
Thank
with
you.
that correction by our Secretary of the Board. All those in favor say aye.
Aye.
Aye. Opposed?
Thank you.
Approved. Thank you.
Okay, next case is V-11061-15-UP-1. This is a use permit request by Bridget Obikoya to permit a setback of 4.5 feet to the eave and 5 feet to the wall from the right side property line instead of 10 feet as required, 4.5 feet to the eave and 5 feet to the wall from the left side property line instead of 8 feet as required, and 17.8 feet to the stairs, 19.8 feet to the rear patio, and 20.8 feet to the rear balcony from the rear property line instead of 21 feet as required, and finally an aggregate side yard of 9 feet instead of 18 feet as required. It's for the construction of a new 3-story detached single-family home with second and third floor and front balconies, a rear second-story balcony, a rear raised patio with stairs, and 2 rooftop decks. This is in the R27 zoning district, premises known as 2135 South Oxford Street. Motion is to deny this case to the October 14th BZA hearing. Defer this case to the October 14th BZA hearing.
I so move.
Second. Okay, so moved by Ms. Freshman, seconded by Mr. Melnick to defer this use permit request to October. All those in favor say aye.
Aye.
Aye. Motion carries.
Okay. Next case is V-11062-15-UP-1. This is a use permit request by Laura Kozel and Mary Hanna to permit a setback of 7 feet to the eave and 8 feet to the wall from the North Quincy Street right-of-way instead of 25 feet as required. It's for the construction of a new 1-story right-side addition. It's in the R6 zoning district, premises known as 4007 20th Road North.
Do you have any questions of staff? Hearing none, could I hear from the applicant, please? Welcome.
My name is Laura Cassell. Mary Hanna is unable to speak because she had dental surgery today, so I'm speaking for both of us.
Oh, no.
I'd like to thank Drew for making this application go through smoothly. It was the first time I ever did anything like this. The only thing I want to add to the application is just 2 points. One is when I bought my house in 1980, my parents gave me the down payment. And I was a graduate student at George Washington University and had the nerve to buy it. I love the house. I love the bungalow look of it. So the first thing I want to assure the board is that our design fits the bungalow look of our house. We're not going high up. We're just bumping out the side of our house wide enough to pay back my mother for that original down payment because she's moving in to live with us. She's 83 years old. So we're putting a master bedroom and a bathroom for her, and I'm expanding my study so that I can start doing more hybrid classes at home so I could be there to take care of her. So thank you for considering my case.
Thank you. Any questions or comments or motion?
Mr. Chairman,
Ms. Malice.
I move that the Board of Zoning Appeals adopt the attached resolution approving use permit V-11062-15-UP-1, subject to the conditions listed in the resolution.
Second.
It's been moved by Ms. Malice and seconded by Mr. Smith to approve the request. All those in favor say aye.
Aye.
Aye. Granted.
And next case tonight is V-11063-15-UP-2. This is a use permit request by Stephen Keller, Diane Gianelli to permit a setback of 16.7 feet to the eave and 18.7 feet to the wall. A new 1-story addition from the North Garfield Street right-of-way instead of 25 feet as required. Construction of a new 1-story rear addition. It's in the R6 zoning district, premises known as 2914 4th Street North.
Questions of the staff? If not, could we hear from the applicant, please?
It's been a long evening. Donald Trump is done insulting people. My wife wants a new kitchen, and marital harmony hangs in the balance. And if I might note, I was alarmed to see a September 16, 2015 deadline, but I was delighted to hear that in a previous case that was a typo. I pray it is in mine as well.
That's 70 minutes to get it done.
September 11th, 2015. Any questions for the applicant?
Motion?
Just a minute, I was going to say, give our regards to Mrs. Craven, who was our former colleague here. She lives across
Oh,
the
yes,
street.
indeed.
They're wonderful neighbors.
Ms. Freshman.
Move the Board of Zoning Appeals adopt the attached resolution granting use permit V-11063-15-UP2, subject to the amended conditions listed in the resolution 2016.
Is there a second?
Second.
Been moved by Ms. Freshman, seconded by Mr. Smith. All those in favor say aye.
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 Motion carries.
Thank you.
Tell Ms. Craven that Charles Smith and the board say hello. It was a little long ago that she was here.
Okay, the next case is V-11064-15-UP-1. This is a use permit request by Peter and Julie Kaplan to permit a setback of 5 feet to the addition from the left side property line instead of 10 feet is required, and an aggregate side yard of 15.6 feet instead of 18 feet is required. It's for the construction of a new 1 and a new 2-story left side addition. It's near a 6 zoning district, premises known as 724 South Adams Street.
Any questions for the staff? Now, can we hear from the applicant, please?
Good evening, I'm Peter Kaplan. The only comment on the packet is the same date expiring tonight.
Oh, dear.
Where that came from?
Copied the
Man.
same conditions over
This is
and over
embarrassing.
again.
16.
Automatically, got to write software so that will automatically update when you do.
Because it'll update you to something you don't want.
That would be a macro.
Yeah. So any questions for anybody?
Motion? I move the Board of Zoning Appeals adopt the attached resolution approving use permit V-11064-15-UP1, subject to the amended conditions listed below, 2016.
Second?
Second.
Mr. Chairman, I'll second it. And, this is one of those substandard lots in width, and so it's obviously a need to do something with respect to the width.
It's been moved by Ms. Freshman, seconded by Mr. Smith. All those in favor say aye.
Aye.
Aye. Opposed? Motion carries unanimously.
And next case is V-11065-15-UP-1. This is a use permit request by Michael and Andrea Ross to permit a setback of 4.3 feet to the egress window well, 6 feet to the eave, and 7 feet to the porch base, and also 8 feet to the 2-story rear addition from the right side property lines to 10 feet is required, 4.2 feet to the eave, and 5.7 feet to the wall if a new 2-story rear addition from the left side property line instead of 8 feet is required. Finally, an aggregate side yard of 8.5 feet instead of 18 feet is required. For the construction of a new 2-story rear addition with a right side porch, right side egress window well. It's in the R5 zoning district, premises known as 1240 North Taylor Street.
Any questions for staff? Can we hear from the applicant, please?
Good evening. My name is Andrea Ross, and I am the current owner and applicant. My husband and I have submitted for a 2-story addition to our house, including a front porch and a back covered porch. We love our neighborhood and our neighbors, and that is why we are putting in this request for an addition. We have informed all our current surrounding residents of our building plans and received some signatures from them as well. We have read the staff suggestions and understand it. However, we just wanted to give our thoughts on the egress window well. We were trying to put an egress close to the current basement that is in the structure as well. So we were trying to put one, further in on the building structure. There was also the thought of adding a window for natural light as well.
Mr. Chairman? Just, in terms of the neighbors that we have signatures for, we have a signature for 1236, but nothing for 1244. That would be your other neighbor?
There should be 1244. 1244 is number 5.
I see it.
Oh, I'm sorry.
Okay.
I missed the whole page. Oh, you're fine. Thank you.
Any other questions for the applicant? I do not have any speaker slips.
Motion?
Ms. Freshman.
I move the Board of Zoning Appeals adopt the alternative resolution approved as advertised for use permit V-11065-15-UP1, subject to the conditions amended to 2016.
I'll second.
It's been moved by Ms. Freshman and seconded by Mr. Melnick. All those in favor say aye.
Aye.
Aye. Motion carries.
Okay, brings us to our last case tonight. It's V-11066-15-UP-1. This is a use permit request by Kevin and Ann Peterson to permit a setback of 2.3 feet to the eave, 3.4 feet to the wall from the left side property line instead of 10 feet is required. Also an aggregate side yard of 10.3 feet instead of 18 feet is required. It's for the construction of a new one-story left side garage addition. This is in the R6 zoning district, premises known as 1812 North Herndon Street.
Questions for the staff? We hear from the applicant, please.
Good evening. My name is Ann Peterson. My husband and I purchased our Rambler-style house almost 5 years ago, and since then our family has grown and we are planning an addition to make this our forever home. This will provide us with an office space for me as I now work from home most days and a first-floor guest room for my aging parents. We considered various scenarios to meet our needs, and our proposed design leverages the existing house as much as possible, has minimal impact to the green space on our lot, and fits within our budget. Our house is the only house on our street with a carport. Our lot widens a bit in the back, so the front of the carport is 3.4 feet from the left side property line, whereas the back of the carport is 5 feet from the left side property line. The carport is integrated with our house by the continuous brick on the lower level of our house and a continuous roof. Our proposed design keeps the carport structure, which includes brick walls, concrete slab, and wood framing, and we also plan to reuse the existing windows. Our special permit application consists of 2 requests. The first is to repitch the roof of the carport to align with the pitch of what will be a new roof on our house. This will make the house more aesthetically pleasing, and leaving the roof as is will have a negative impact on the overall design. The second is to convert the carport to a garage. Our carport is currently enclosed on 3 sides, and enclosing it with a door will make me and my family safer. We love our neighborhood, however, we do have safety concerns. For example, last month there was a car theft from a driveway and an attempted sexual abduction blocks from our house. Additionally, there have been recent accounts of mothers being approached by strangers while getting their children out of their cars. This has been on the mom's listserv and has happened in our neighborhood. The carport changes along with the overall project are consistent with the look and feel of our neighborhood, and our neighbors have had positive reactions to our plans. Our neighbor to the left, who is right there you can see from the picture, Bill Gerhardt is supportive of our project and is one of the signatures in the application.
He's still very active. Does anybody have any questions of the applicant? I think our architect is here as well. Mr. French?
I'm Tom French, and as briefly as possible, we propose to renovate an existing section of the Petersons' home by adding a steeper roof in place of the present low slope roof that you can see in the photographs, in order that the wing be architecturally harmonious with the second floor addition we proposed by right. We also propose to add a garage door to improve the facade and enhance security for the owner, as she had mentioned. The existing structure is enclosed on 2 of 3 sides. It's open to the street, but the owners believe there may have actually been a garage door at some time due to their investigation of the ceiling and noticing some holes where there may have been a door hung. We intend to build on the existing foundations that we believe date to the house's origin. The only additional encroachment that we propose would be an extended eave at the side gable, which we are willing to reduce if the board prefers that. The alternative resolution is unsatisfactory because in addition to increasing the cost of the project significantly by requiring the demolition of the existing encroaching wall, foundation, and footings, we'd be asked to replace it with a new wall, foundation, and footings 1.6 feet away. And the resulting garage would be 10.4 feet wide rather than 12 foot wide, which in my professional opinion is too narrow to accommodate the thickness of the wall, the standard 8-foot wide garage door, and necessary room to open car doors internally. Since the garage at that point would be unusable, the Petersons would actually be losing one off-street parking place, which in Lion Village strikes me as particularly problematic. Our intention is to make the present situation no worse and to enhance the livability and appeal of the existing property. We've gained the consent of all the adjacent neighbors and hope you can consider our proposal positively. Thank you.
Thank you. Any questions from the board? I thought I'd commend Mr. French. I found the elevation that he created for the left side elevation showing a dotted line of what's existing and what's being added was very, very helpful to understand this. Thank you. Anybody want to make a motion?
Well, Mr. Chairman,
Mr. Smith.
I'm going to pick up where Ms. Freshman left off and move adoption of the alternative resolution approving use permit V-11066-15-UP1 as advertised for the setbacks as described in the advertisement, with the conditions that are also described in the staff report, with the exception of the date that the project has to be begun being amended to be 2016, September 16, 2016.
Second.
It's been moved by Mr. Smith, seconded by Ms. Freshman to approve the request, the alternative resolution. All those in favor say aye. Aye. Opposed? Motion carries. It's granted. Good luck. We have 2 sets of minutes.
Mr. Chairman, I appreciate the July 15 minutes with that little note. That's exactly it. Adoption of the July 2015 minutes.
Second.
It's been moved and seconded. All those in favor say aye.
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 Move approval of the August 12, 2015 minutes.
Second.
It's been moved and seconded. All those in favor say aye. Aye. Abstentions?
Abstention.
Okay. Mr. Melnick abstains.